connect to live custom stream. Now it's loading. We're live.
Good afternoon, everybody. This is the House Judiciary Committee. It is Tuesday, January 26th at 1:40. Sorry, we're running a little bit behind. Members, remember to mute yourselves. Only unmute yourselves when I recognize you to ask a question. Witnesses, same deal. Please, you'll unmute yourselves when I recognize you to present your testimony, but please stay muted until then. If you are operating off of a cell phone, that's fine, but please make sure you're muted in advance. By our guidelines, the bills either get 2 minutes for the sponsor and 1 minute for witnesses, or 3 and 2. Most of our bills are 3 and 2 today. The one bill that is a 2 and 1 is our first bill, and that's Delegate Moon's bill, House Bill 126, because it's a rerun of a bill that we passed last year. Everything else, House Bills 235, 128, 223, 402, 131, 316, and 102. We'll have 3 minutes for the sponsor, 2 minutes for the witnesses. And with that, members of the committee are asked to ask questions, not make statements followed by "isn't that so?" They need to ask questions on the bill. With that, let's start with House Bill 126. We're going to start with Delegate Moon. And let's see how many you have. Okay, so it's just Delegate Moon, and then we'll hear from Corey Johnson from JOTF. So let's go, Delegate Moon.
Thank you, Mr. Chair, colleagues. House Bill 126 is a repeat of a bill from last year, House Bill 82. It passed unanimously out of this committee, so you all already voted for it. And it was practically unanimous on the floor, 129 yes votes, and we just ran out of time with the pandemic to get it through the Senate. Just to refresh your memory, this is a bill that deals with pretrial services. This is my third year I'm trying to get at this issue of counties charging defendants for these alternatives to cash bail. It sort of goes against the purpose for a lot of us in pushing the cash bail reforms, which the courts did a few years ago, which was to make the reason people are held before trial due to whether they're a public safety or flight risk, and not whether they have money in their pocket. So during COVID, we're obviously relying on this more. And so you can more clearly see that it's important to not have people stuck in prison with other people exposed to COVID solely for the reason that they don't have cash in their pocket. So the compromise bill we came up with after several years that finally got MACO and the ACLU on the same page was to make as a condition of a grant that is offered to counties to provide these alternatives that they cannot charge defendants for those services. This grant fund is also sunsets in 2023. We've been adding new requirements into it over the years, so the bill also extends the sunset to 2028. I'll stop there to answer any questions. One key flag I will point out that appeared suddenly in this year's fiscal note is that the bill does not apply to Baltimore City. I know that's of interest to some folks, and that's because Baltimore is not eligible for grants from this fund, since it's the Department of Public Safety that runs the pretrial services there. So I want to be very clear about that since we have bills coming up after me on that topic.
All right, thank you very much. Are there questions for Delegate Moon? Seeing none, thank you very much. We're going to hear to one witness in opposition, that is Corey Johnson.
Good afternoon. My name is Corey Johnson, and I'm an attorney and the Senior Policy Research Analyst at JOTF. We oppose House Bill 126 as a means of ensuring that we decriminalize poverty and race in the state of Maryland. The Fifth Amendment, incorporated to the states through the 14th Amendment, requires that no person should be deprived of life, liberty, or property without the due process of the law. Yet each day, thousands of innocent pretrial individuals are plagued with thousands of dollars in pretrial fines and fees at no expense to the state. House Bill 126 merely incentivizes jurisdictions to access a pretrial grant fund and does not require individual counties to provide pretrial expenses, which still leaves the ultimate financial onus on the individual. While we recognize the intent of House Bill 126, it does not guarantee pretrial services. Additionally, this legislation requires jurisdictions that receive the grant funding to use race-neutral risk assessments. This is inherently oxymoronic, as risk assessments are inherently racialized. Risk assessments are so contentious that the coalition that advanced pretrial reforms in 2017 fails to reach consensus on the use of risk assessment tools. The nation's leading pretrial experts, the Pretrial Justice Institute, has denounced the use of risk assessment tools due to the overwhelming amount of racial disparities. Even if a practice is on its face neutral, it can still have a discriminatory impact and effect that renders it unconstitutional. As we have seen with the notable constitutional law Supreme Court cases of Washington v. Davis and Arlington Heights. A facially neutral practice and policy that disadvantages minorities can be rendered unconstitutional if it meets the disparate impact, as well as if the purpose is discriminatory. For the reasons above, we at JOTF oppose House Bill 126.
Thank you very much. There's a question from Delegate Moon.
Thank you, Mr. Chair. I just wanted to ask if the testifier was aware that the race-neutral language is existing law that came in on a different bill last year regarding new requirements on the pretrial grant fund. This doesn't actually change that. Thank you.
I'm aware, Delegate Moon, that it doesn't change that.
Are there further questions for this witness? Seeing none, thank you very much. That concludes the testimony on House Bill 126. We're now going to go to Delegate Juanica Fisher. I didn't see her. Great. Delegate Juanica Fisher on House Bill 235. Delegate, there are 3 people who, yourself plus 2. Yes, yourself plus 2 to testify orally on this. So you're going to get 3 minutes. They're going to get 2 minutes. And whenever you are ready, Delegate Fisher, go right ahead.
Thank you, Mr. Chair. Just loading my notes. Thank you, Mr. Chair, Madam Vice Chair, and members of the Judiciary, the most hardworking committee. My name is Delegate Juanica Fisher, and I'm pleased to reintroduce HB 235. It was formerly last year, HB 524, the Pregnant Incarcerated Continuity of Care Act. Say that 3 times. The purpose of this bill is to ensure that a pregnant incarcerated individual is screened for substance use disorder at the time of intake. Incarcerated women are more likely to suffer from drug addiction and abuse. According to the NIH, drug use has been proven to complicate pregnancy, including fetal growth issues, placenta abruption, preterm labor, and other issues. Women who stop using drugs such as opioids can suffer from withdrawal symptoms and more. The aforementioned issues can really worsen with the lack of medical treatment. Every person should be afforded the opportunity to receive adequate health care while pregnant. If passed, this bill will provide a few necessary measures to reduce the afflictions that pregnant women, pregnant individuals, face. A positive, if a person is found to have a positive pregnancy test, scores on positive substance use and drug screening, they would be immediately referred to a behavioral health care provider. Further, if a pregnant incarcerated individual receives medication or treatment for opioid use disorder due to incarceration, prior to incarceration, and wants to continue that treatment, the correctional unit shall ensure that the individual receives that treatment and doesn't have a break in care. I hope that you join me in standing up for health access, especially those that are most vulnerable in our system. And I ask for our committee's favorable report on House Bill 235. And I will leave the rest to the other proponents for this legislation.
All Right, we are going to go now to Joan Shreve from the Office of the Public Defender. We're looking for Kim Haven, who has not yet entered the room, the waiting room. And I see Delegate Erican has a question. We'll take at least Ms. Shreve, and then we'll go to questions. 2 minutes, please, for Shreve.
Thank you, Chair Clippinger, Madam Vice Chair, and members of the Judiciary Committee for having me today. My name is Joni Shreve, and I'm a social worker at the Maryland Office of the Public Defender Post-Conviction Division. I have been working for the office since 2013, and my work primarily involves assisting clients who are serving long-term sentences in the Division of Corrections and helping people for release from Maryland prisons. Many of my clients often experience significant barriers to successful reentry, including navigating access to medical care, substance abuse and treatment, and insurance. Social workers at the Public Defender's Office often work directly with clients to conduct biopsychosocial assessments, provide treatment recommendations, and assist clients with alternative plans. Often this includes identifying treatment resources to address substance use disorders. The Maryland Office of the Public Defender respectfully requests that the committee issue a favorable report on HB 235 to help reduce barriers to life-saving treatment for pregnant incarcerated women with substance use disorders. Entering and exiting prison are destabilizing events that require proper planning and support to ensure an individual's needs are being met. This is especially crucial for pregnant women who have complex medical needs or are at high risk of complications in prison. Medication-assisted treatment is the recognized standard of care to reduce the risk of severe or fatal complications. Maternal opioid use has quadrupled between 1999 and 2014, and the number of incarcerated women in Maryland has also increased significantly. An estimated 4% of women entering prison are pregnant, and incarcerated women have higher rates of opioid use. As Delegate Fisher highlighted today, withdrawal symptoms can be extremely dangerous during pregnancy and can occur within 8 hours of last use. Immediate screening and treatment must be offered to mitigate these risks. Ensuring the continuity of care between the community and prison will help reduce the risk of relapse, pregnancy complications, and overdose. Medication-assisted treatment with counseling, support groups, and other assistance can lead to greater adherence to treatment, prenatal care, and reduce the risk of relapse or overdose. This will help promote long-term recovery and the continuation of treatment after release.
Okay, well,
So we support this bill.
Thank you. Thank you, Ms. Shreve, and I'm sorry you had to
Thank you.
Delegate Fisher there for a moment.
No worries. Thank you so much.
Okay. Delegate Fisher didn't say anything incriminating. It's fine. All right. I didn't see Kim Haven enter the room. If she wants to submit something in writing, of course, the committee would be happy to see it. But for now, Delegate Erican.
Thanks, Mr. Chair, and thanks for this bill. I have a couple questions. I just pulled up the bill from last year. So I know that when we went to the prisons as a committee, they did tell us that they do this. Is the issue here that they aren't doing it quickly enough? And has there been any sort of documented adverse outcomes with pregnancies that that we can speak to, so we can get sort of a baseline for how often this happens right now? That's number one. And number two, does your bill allow for women to refuse consent? I mean, not all women want to be treated as a monolith. Not everybody wants the same treatment. So does this bill allow for them to say no?
Yes, Delegate. It's my understanding, and counsel can correct me, that they can accept the treatment or not. From my understanding from the advocates, and I'm not exactly sure where Kim is. I think she would give a better response, and I can have her, Ms. Haven, kind of maybe email you back, Delegate, on the numbers on that part. But there definitely has been issues on the continuation of care, and definitely when people are in the intake process as well, that I can speak to. But I will leave it to her to try to answer your questions more fully than I can. So I'll ask her to email you a response. So
okay, so I think I understand. So the problem is these women are most likely already on some kind of treatment plan. They come in, they're not screened quickly enough, so there's a gap in their medication.
Yeah, and the withdrawals and different things can be quite problematic.
Of course. Okay, thank you very much.
Delegate Cox, then Delegate Deborah Davis.
Thank you, Mr. Chairman. Thank you, Delegate. I know that we had worked together on this type of legislation, so I commend you for that focus and appropriate assistance. I did have real quick to dovetail off of what Delegate Erickson said, just regarding consent, and then also specifically on page 2 of the bill, it says on lines 24 through 26 talks about all available treatment options being provided, and including the initiation of medication. And I just wanted to ask you, does that, it appears to me to include abortions. Is that the case to your understanding?
That is not the case to my understanding. It's the care, especially due to drug issues and other issues that the person may have. That is not my understanding.
Okay, thanks so much. And then about the consent issue, is that something that's just as a matter of practice, you think? Because I know that.
Yes, I can refer and email the committee from council, but when with the bill drafters and when the other advocates have worked on this legislation, you would consent to the care that's given to you. So I will have someone smarter than me reaffirm that fact to the committee, but that is my understanding of the legislation.
Okay, thanks so much.
Delegate Deborah Davis, please. Then Delegate Williams.
Thank you, Mr. Chair. Delegate Fisher, thank you so much for this important legislation. My question is, does the legislation address if the facility fails to do what they're instructed to do?
It does not necessarily, oh, am I on? Okay. From what I have in the legislation, Delegate, it's not that it's like tied to a funding that they won't get or something, what is the word? Like a punishment for not. I think it's just establishing a normality of care and allowing individuals to continue that. I can explore that concern with the Department of Corrections. I know that as they come to our committee, they have a lot to do. And so I think our initiative is to start the ball moving in the right direction for these women. So I don't know where they would stand on something like that, but yes, that's my answer to your question. And I just saw Ms. Haven enter our Zoom as well. So she wants to add to that later in her testimony. She can as well.
Okay, so here's what we're going to do. We will give Ms. Haven the opportunity to speak for a minute, and then we will take, I saw Delegate Williams' hand go up and then come down. Delegate Williams, are you?
Well, I'm hoping that now that Ms. Haven's here, she might be able to address the question that I have. And if not, then I'll raise my hand again.
All right, we're going to give Ms. Haven the opportunity to speak for a minute. And then if there are any further questions, we can address those and then go from there. So Ms. Haven.
Thank you so much, Mr. Chairman, members of the committee. I'm sorry I had trouble logging in for some reason. I'm here today in support of HB 235. Pregnant incarcerated individuals represent a very unique and vulnerable population. The healthcare needs that they have, to include mental health, to include substance use, get minimal care at best behind the walls. And what we're talking about today is this transition of care, this continuity of care. Currently, there is no coordinated level of care from public safety to community-based organizations. And that transition time between when someone is being released and when they're able to access the reproductive health care that they need in the community represents a very, very high risk period for them. I also want to point out through this bill that this really is good risk management. This committee heard and supported this bill last year, but this bill does represent good healthcare, good management risk for institutions, for the state, for local jurisdictions. And now, given the impact of COVID and the demand for pregnant individuals to be released, the need for continuity of care and transition back to the community is more acute than ever. Thank you so much, and I'm here to answer any questions on camera or double back with you offline.
All right. Now, are there further questions for the full panel? All right. I don't
Oh.
see anybody's hands raised. And with that, if that's the case, then that'll conclude the testimony in favor of the legislation. And that concludes the testimony altogether on House Bill 235. So thank you all very much.
Thank you, Mr. Chair. And I'll circle back with the delegates that I said I would circle back with.
Okay. We're now going to go to a little out of order to Delegate Love's bill, House Bill 223. And there are 1, 2, 3 people on, as well as Delegate Love to testify. Delegate Love will get 3 minutes, and then we will hear from Scott Schellenberger, Ashley Inderfirth from the Montgomery County State's Attorney's Office, and Catherine Marsh from the Prince George's County State's Attorney's Office. So we'll hear from them. So we'll start with, and then we'll take questions after that. Start with Delegate Love. Go ahead for 3 minutes.
Thank you, Mr. Chair. Mr. Chair, Madam Vice Chair, members of Judiciary. For the record, I'm Sarah Love, here to present 223, seeking to close a loophole in our law regarding persons in authority. I'm bringing this bill because of a constituent, but also because of the many examples that the experts who practice in this field, several of whom you will hear from, confront on a regular basis. I have a constituent who has spent years seeking justice for his daughter. Her life, their whole family's lives, have been torn apart and they are still suffering. His daughter, who struggled with mental health challenges, found an interest in music. Her father, wanting to support her, got a reference from a professor at Montgomery College for her to take lessons from an adjunct professor. This adjunct was in his 50s and he appeared kind. Her father drove her to this man's house every week for nearly 2 years. The father sat in the house while the teacher took the young woman into his soundproof music room. Unbeknownst to the father, during that time, the man was using his position to gain her trust and touch her inappropriately. When she turned 18, he began to have sexual intercourse with her. Over this time, the behavior moved out of the home music studio. He took her for car rides and gave her alcohol and cannabis to lower her inhibitions. Not long after, the relationship ended, the young woman's mental health declined. She became a picky eater. She obsessively washed her hands, brushed her teeth. She had irrational fears and disturbing thoughts. Finally, full of guilt and shame, she told her father what had happened. Her father confronted the man, who apologized. He said he was ashamed of his actions, that he knew she was fragile and that he had hurt her deeply. He knew what he did was wrong. The family sought justice for their daughter and to prevent this man from doing this to another young woman. They went to the Montgomery County State's Attorney's Office, only to find out that the state could not prosecute him because of a loophole in the law. The young woman was 17, which meant she could have a consensual sexual relationship with anyone over 18, unless the offender was a family member, household member, or had care and custody over her, or he was a school employee who supervised her. In this case, he met none of those definitions. Her father did not relinquish care or custody to the offender, and the offender didn't meet the definition of person in position of authority under current law. The awful irony is that if the father wasn't comfortable leaving his 17-year-old daughter in the house of a man in his 50s, and that he sought private instruction rather than having her receive music lessons at school. If he had left the house, or if the offender was a teacher in public or private school, the state's attorney could have prosecuted, but they couldn't. Members of the General Assembly have worked on this issue before, including the current chair of this committee, as well as then Senator Raskin. And on a nearly unanimous vote in both chambers, they made the law stronger, but this loophole remains. In closure, I understand my time is gone. As you will hear, this is a recurring problem. I ask you to finally close this loophole and bring justice and closure to this family and many others. For the foregoing reasons, I request a favorable report. Thank you.
Thank you. State's Attorney Schellenberger for 2 minutes, please.
Mr. Chairman, Madam Vice Chair, members of the committee, thank you so much. As Delegate Love said, each of the state's attorney's offices have a case and example of this where there's a loophole. In Baltimore County, we have a 16-year-old, and that's where this law really comes into play, 16 and 17-year-old female victims, although it can work for both sides. She was taking private fencing lessons, and the fencing coach would drive her home each evening that they had practice. He had convinced the parents that he should drive them home to save them time. They would then go to a remote area where unfortunately they would have sex. Now, we did try this case, but we tried it under a theory of him having care and custody. We tried to trial the traditional child abuse. Unfortunately, it was thrown out because they argued that a 16-year-old, if she can drive herself home, and the parents were just doing this as a convenience, he was not a family member, he was not a household member, and he did not have temporary care or custody, and therefore we lost the case, even though he was in a position of authority. She is 16, he is 31, she idolized him. It was a fencing coach that was going to lead her to other places. That is why we need to expand Criminal Law 3308. It's not just teachers who have control of our young students. And that's all 308 that part applies to right now. Music teachers, soccer coaches, Boy Scout leaders, Girl Scout leaders. We could go on and on. We all have family. We all know how they fit into our lives. We believe this is a loophole that needs to be filled. I appreciate Delegate Love coming forward with this, and I would urge a favorable report. Thank you.
Okay, if I could ask Ashley Inderfirth, please, for 2 minutes.
Thank you, Mr. Chairman, Delegate Love, and members of the Judiciary Committee. My name is Ashley Inderfirth. I am here today to speak in support of House Bill 223. I am a prosecutor in the Special Victims Division of the Montgomery County State's Attorney's Office. I'm also speaking on behalf of Debbie Feinstein, who is the chief of the Special Victims Division and also the chair of the Choose Respect initiative in Montgomery County that works with teens and healthy dating relationships. Ms. Feinstein has also submitted written testimony that I'll be drawing from in my remarks. Section 3308 of the Maryland Criminal Law article currently precludes certain individuals who are in a position of authority over a minor from engaging in sexual conduct with that minor. The law essentially recognizes and criminalizes the exploitation of that inherent power dynamic associated with sexual conduct between a minor and a person who is in a position of trust. The current law, however, as you've heard, narrowly defines that person in a position of authority, and essentially anyone who is working in a private capacity as a teacher or a scouting leader or tutor cannot be prosecuted under this statute. As Mr. Schellenberger mentioned, this comes up regularly with respect to especially 16 and 17-year-olds who do have a fair amount of autonomy. And so it's very difficult to establish care and custody of them unless it's a family member or a household member. So Ms. Feinstein actually is the person who handled the case that Delegate Love spoke about that really exposed this glaring loophole in the law. The victim, who was age 17 at the time, was receiving private music lessons from a teacher in his 50s. The lessons were conducted in his home, and because the father remained immediately outside of the room, we were unable to establish that care and custody element. He engaged in sexual conduct and ultimately sexual intercourse with this 17-year-old girl. But because he was not employed by or under contact with a school, Ms. Feinstein was essentially hamstrung and was unable to prosecute him for these sexual offenses. He was in no less a position of authority than anybody who is employed by a school. And for those reasons, we do believe that it is very appropriate to expand the definition of a person in a position of authority to include people who hold this position of trust and who exploit that trust. For those reasons, we do strongly urge the committee to issue a favorable report on HB 223.
Thank you very much. We'll go now to Catherine Marsh.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. For the record, I'm Catherine Marsh, Special Counsel and Assistant Chief of the Special Victims Unit for the Prince George's County State's Attorney's Office. One of the roles of the Special Victims Unit is to stand up and seek justice for minors who are sexually exploited. For many minors in this state, we fail because of a loophole that currently exists in the 4th-degree sexual offense statute. As the law stands now, a person in a position of authority is only criminally liable for sexual exploitation of the minor if the person in authority is employed at the same school that the minor attends. Last year, we had a volleyball coach who engaged in sexual relationships with more than one player who were between the ages of 16 and 17. As the coach was not employed at the minor's school, we were unable to charge. Our case is not unique, as you've heard today. Every year, our unit has conversations with parents and minor victims who have been taken advantage of by adults who hold a position of authority over them, from coaches to scout leaders and camp volunteers. And time again, we have to tell parents and victims that their exploitation is not covered by the law. House Bill 223 would close this loophole and protect our minors who are exploited by adults who hold a position of authority over them, and ensure that we don't have to tell any other parents or children that their exploitation doesn't matter in the eyes of the law. For the foregoing reasons, I respectfully request a favorable report on House Bill 223.
Right, are there any questions for the panel? I see Delegate McComas. Will encourage Delegate McComas to use the raise hand feature in the future, but we'll go to her question now and then the Vice Chair.
Thank you, Mr. Chair. Just briefly, I mean, what is the history of this? Because I think, Delegate Love, have you been before our committee with this before?
No, I have not.
Oh, okay. Anyway, good bill. And I think that, do other states, have they taken care of this loophole, or they don't have a bill, don't have the law that's kind of, you can drive a Mack truck through it like this one? The current law.
I'll leave that to the experts, but my understanding is that each state's laws are written so differently, but others I'm sure know better than I.
Okay, thank you.
I would say that is correct. We did look at several other states, and they have position of authority expanded greater than Maryland's law currently is.
All right, the Vice Chair.
Thank you, Mr. Chair. I want to thank you, Delegate Love. This is a really important bill, a really good bill. So thank you for bringing it to our committee. I was actually wondering the same thing, because unfortunately that's the story of your constituent. It has been before our committee before, perhaps on something else. And then, because I remember being so taken aback that I Googled it and read about it in the paper. But I was just wondering if one of the state's attorneys could tell us, just so we know, like, what is the prevalence of this? Like, what percentage or how many cases, like, does this happen where you aren't able to get a conviction because of this loophole?
So, Madam Vice Chair, if I may, and I'll defer to my other two colleagues, this is a very recurring problem. Unfortunately, because of the way our 4th-degree sex offense statute is designed, it concentrates on 14 and 15-year-olds and those younger, in which we create various statutory penalties because we assume that they cannot consent. They have no legal ability to consent. There's a hole in the law when it comes to 16 and 17-year-olds. And that hole in the law corresponds to people growing up and getting of a certain age. And so when people are in positions of authority like this, particularly, they take advantage. They actually, in my mind, seek out these kinds of jobs. And look, there are plenty of great coaches, music teachers, dance teachers out there who are doing it because they love it and they want to help people advance. But then there are a small number of people who are in fact predators in this way, and they take advantage of this law that has a missing piece to it. But I would say in Baltimore County, and of course you're hearing from Montgomery and Prince George's, the 3 largest counties in this state, we all see this a lot.
Thank you.
I would agree with that. And not only would I agree with that, but I also think there's a dearth of data on how often this occurs because it is not a crime. So a number of these are likely screened out at the police level. And I know that I have declined cases at the investigatory stage because we can't proceed with them. And so those never even make it to our offices.
Thank you.
Agree with all of my fellow prosecutors and would only cite that this problem has increased in recent years because of technology and social media apps and the ability for the adults who are in the position of authority to have communications with these minors outside of the knowledge of the parents. And so I've actually seen an increase as cell phone usage and social media apps have gone up.
Thank you. I support it. It's scary as a parent. Just side note. Thank you, Mr. Chair.
Thank you. Are there further questions for this panel? Delegate Fisher, Juanita Fisher.
Thank you, Mr. Chair. Sorry, I kept trying to put my hand up, but it disappears. Thank you, Delegate Love, for this piece of legislation. The questions I have are probably for your panel. And I appreciate this bill, and I think it's great. I just have a question of the technical part of, you're not pursuing these charges because consent is the issue that you can't establish, and it's the undue influence on the minor who ended up in this relationship with the adult, correct? Right?
Oh, correct. That's what we see the most because in Maryland, the age of consent is 16. And oftentimes the child goes into it believing it's a consensual relationship because of the expectation.
Okay, I just wanted to break it down. So then the parents basically find out this is happening and the parents and or the child come to you, bring the charges. Just follow me for a second, correct?
Sure.
Okay. So then my question really has to deal with then what I believe in this legislation, but I think the nature of like the presenting of who's going to qualify, for example, if you have like a 23-year-old, like someone young who's like the assistant coach on the day, it's very easy to see it with like the 50-year-old and the 16-year-old, you know what I mean? But I've been at plenty of sports camps, all kinds of things where it's like a very young person who also could be in those kind of positions. I just was curious to see what the panel would say to that dynamic of the 16-year-old and the 21-year-old and 23-year-old who is the assistant coach of the soccer team. And the parents are finding out that there was a relationship.
Delegate Fisher, I appreciate that question. And I am sad to say that I have been a prosecutor long enough now to remember when we were testifying to have the teacher, the position of authority added not too long ago. And we had this same kind of debate about what's the appropriate age? Should we put an age on it? And at that one, and again, it was, I don't know, 6-7 years ago, maybe longer than that. I don't want to age myself too much, but it was determined 21 at that point in time. So this is just to go off of the exact same legislation, just to expand the definition of.
And I don't want you to think I'm not supportive. I just wanted y'all's opinions and.
No, it's a great question and one we debated quite a bit. Like I said, I've done this long enough to remember that one too.
And Delegate Fisher, I'll just chime on to that. Obviously, we could have made it 18 because then you're an adult. But we recognize what you're looking at, and that is 18 and 16. That's pretty close, which is why we did put in the bill 21 back in the day when we were focusing on teachers, because that really is a difference. And so that was an acknowledgement back then that an 18 versus 21-year-old, 21 versus 16 is very different than 18 versus 16.
Thank you all for that.
Are there further questions for this panel? All right, seeing none, we thank you all very much. And I think we're going to have to move now. Delegate Malone, are you here? You are. I think we're going to move to Delegate Malone's bill next because we were waiting for Delegate Stewart. We'll figure that out momentarily. So, 1 second, let me get reorganized here. All right, this is House Bill 402, Delegate Malone. are 1, 2, 3, 4, 5, 6 witnesses, 5 in favor, 1 opposed. 3 minutes to Delegate Malone, and then 2 minutes to Chief Judge Morrissey, Joe Riley, Steve Kroll, Scott Schellenberger. And in opposition, then we'll do questions, and then in opposition, the public defender Brandon Rubin. Okay, with that, Delegate Malone for 3 minutes.
Thank you, Mr. Chair. I wish I could defer some of my time to the good state's attorneys who know this bill better than I. The purpose of this bill is to change the definition of absconding. When we worked on the Justice Reinvestment Act, sometimes you find that you have some unintended consequences. And the goal of the Justice Reinvestment Act, which I supported, was to make it a situation where technical violations didn't necessarily put somebody in jail for a long time. But one of the flaws is when somebody is sent to a treatment program. In particular, this bill is currently drafted regarding 8507 treatment facilities, that there's a flaw in the current language if they basically walk off from the treatment program and how the courts handle it. The hope of this bill is to fix that flaw, to give the courts better flexibility and provide a better definition for absconding. There is an amendment, if it hasn't gotten to the file, that is coming, which I believe Judge Morrissey is going to speak to. Not all referrals are for 8507. Sometimes there are other treatment programs, and the purpose is to expand it to be any treatment program that the court would refer someone to. With that said, I would like to now go ahead and defer on to the good Judge Morrissey.
Good afternoon, Chair. Good afternoon, Chair Clippinger. Good afternoon, Vice Chair Atterbury, members of the committee. It's great to see you all again and to appear before you once again. For the record, my name is John Morrissey, and I'm Chief Judge of the District Court of Maryland. The judiciary supports House Bill 402 and has made suggestions, as Delegate Malone just mentioned, to broaden it just a little bit, because there are more than one type of, 8507 is one type of commitment. There are other commitments that we make to residential facilities and other drug treatment placements. To understand why we support this bill, I ask you to start with the premise that drug courts and all problem-solving courts practice rehabilitative justice. These specialty courts favor treatment in lieu of incarceration. In the lead up to passage of the Justice Reinvestment Act, there were many discussions regarding exempting drug and other problem-solving courts from JRA, as problem-solving courts use a graduated sanction method before any type of serious sanction is imposed, just as is the basis for the Justice Reinvestment Act. I thought it was understood that the problem-solving courts were not subject to JRA, but in the magic that occurs in this august body on the weekend before sine die, the specialty courts were left in the Justice Reinvestment Act. This has caused some issues for the problem-solving courts because they do not call their hearing technical violation hearings. They rely on their graduated sanctions, again, just like JRA does, but do not paper the case by detailing each sanction as a technical or non-technical violation. Please remember that all of these individuals are voluntarily in these programs. Recent appellate cases have found that leaving treatment despite the court-ordered placement is a technical violation and subject to the presumptive caps and violation of the prohibition in Justice Reinvestment Act. As the foundational underpinning of these drug courts is placement for treatment, we believe that leaving such treatment is not a technical violation, but rather is a non-technical violation. It's considered a very serious violation by the judge in the court program. These individuals have simply walked away from treatment in violation of the very purpose of a drug court, and that's to get them into treatment. House Bill 402 fixes this issue. The one suggestion that we made, again, as I repeated before, was to expand the definition to apply to any court-ordered placement and not just an 8507 placement. I thank you all for consideration and urge you to vote in favor of House Bill 402.
Okay, we'll go now to Joe Riley. Joe Riley for 2 minutes.
Hey, Chair Clippinger, Vice Chair Atterbury, members of the committee. I'm Joe Riley. I'm the state's attorney for Caroline County and the legislative chair of the Maryland States Attorneys Association. We seek a favorable report on House Bill 402. Maryland's recent adoption of the Justice Reinvestment Act had as one of its primary goals to reduce selectivity in Maryland's prison population and use the resultant monetary savings to provide treatment to offenders before, during, and after incarceration. In simpler terms, the underpinning of the JRA is a shift in philosophy from the jail bed to the treatment bed. In the years following the JRA, we in the Maryland States Attorneys Association have seen a pattern in incarcerated individuals being placed in treatment facilities and those individuals walking off from the treatment facility. Due to how the sentences are modified, the incarcerated individual, when they are placed in that facility, are under the supervision of the Department of Parole and Probation, not the Health Department. In a recent case, the Court of Special Appeals has defined such an action as a technical violation as defined by the JRA and subject to the sanction limit described in Maryland Criminal Procedure 6223. This creates a perverse incentive to the incarcerated individual who has been given the option of treatment. They can stay in a placement and continue the hard work of sobriety, or they can walk off and be subject to a 15-day maximum penalty, be continued on supervised probation, and not have to return to the treatment facility. The state believes that this bill will correct that perversion, and we ask for a favorable report on House Bill 402.
Steve Kroll is on mute.
Good afternoon, Mr. Chairman, members of the committee. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, the Executive Director of the Maryland State's Attorneys Association. I want to thank Chief Judge Morrissey first for MDEC and for also taking my testimony and saying exactly what I was going to say. So I'll say thank you to that, and I agree.
Maybe the best testimony all day so far. All right. And Mr. Schellenberger.
I could beat it by saying ditto, but I think Mr. Riley covered it all, and I would agree with Chief Judge Morrissey's amendment. I think we should expand it, and I would reinforce that this is actually the best mechanism to protect the individual who's got a drug problem and walked away, and the hope at the end is to get them back into drug treatment to make sure they can deal with their problem. But I would agree with everyone else. Thank you.
Okay. Let's go to questions, and I see Delegate Williams.
Yes, thank you. Thank you guys so much for bringing this legislation. I just had a really quick question. I noticed you mentioned that the bill would change this from a technical violation to a non-technical violation. And so my question is, are there any penalty differences to the defendant by the change from the technical violation to the non-technical violation? And if so, what would be the ramifications to the defendant by that change in category, or penalty to the defendant because of that change in category?
Thank you, Delegate, for the question. The answer shortly is yes, it does change. The technical violation has a tiering recommendation of 15 days, 30 days, 45 days, then the balance of the sentence for any third or greater violation under the technical provisions. Also, a technical provision, even though it's classified as a technical, could still have the balance of the sentence if the judge hearing the case determines that that is a danger to society at large. They can increase those penalties. And with it not being a technical, they are subject to the balance of their sentence. However, I think it's important to know that a person that has an 8505, 8507 placement, if they're going into treatment and then they get out and they only have a 15-day sanction, and then they have the balance of their sentence suspended, they can't, there's not going to be an incentive to go back to treatment and go into that long-term facility. Whereas if they have that balance of the sentence, they can refile for another 8505, 8507 placement, and then get that subsequent to them having that time in effect over their head. Unfortunately, I mean, that's the way that the system is done. I don't think you would see anybody go to an 8507 placement if they only had a 15-day penalty over their head.
Thank you for answering that.
No, thank you very much. Are there further questions for this panel? All right, seeing none, that's fine for those in favor. Now we'll go to the opponent. That's Brandon Rubin from the Office of the Public Defender.
Good afternoon, and Chairman Clevenger and
Madam Vice Chair Arterberry, members of the Judiciary Committee. My name is Brandon Rubin, and as a citizen of Prince George's County and an attorney at the Office of Public Defender, I speak in opposition to House Bill 402, which seeks to add the definition of absconding in Section 6-101. First, the bill is unnecessary. If an individual leaves a drug treatment facility without good reason, the Department of Parole and Probation can take that into account, and indeed, nothing is stopping that act from being the sole predicate for alleging the non-technical violation of absconding at any violation hearing. So it's a duplicative bill. Moreover, even if an individual leaves a treatment facility and it's considered a technical violation, a court's not hamstrung. Under Section 6-223, subsection D3, a court's free to impose a sentence that exceeds the presumptive limits for technical violations. So that's another reason why it's duplicative. Second, as explained in Brendoff v. State, under 8507, individuals are placed under the supervision of the Department of Parole and Probation, not drug treatment service providers. Accordingly, as it's written, this bill would contravene the umbrella statutory scheme and contradict this body's grant of supervision authority to the Department of Parole and Probation. Leaving drug treatment programs literally cannot constitute absconding because drug treatment programs don't have the authority to supervise anyone under this statutory scheme. Third, it's easy to see how this bill would lead to absurd results. For example, imagine if the drug treatment facility doesn't give permission to a person to leave, like one of my clients, but a person leaves the facility at the direction of his probation agent for a more suitable placement. That person, if this bill were to be passed, could be found to have committed the non-technical violation of absconding under this bill. There's a reason, in my view, that the Department of Parole and Probation was given supervision authority as opposed to drug treatment facilities. The drug treatment facilities are service providers on the person's path to rehabilitation. As long as that person is in contact, as was the case in Brendoff with the Department of Parole and Probation, they have not gone off the track on their road to rehabilitation. And I point out, in Brendoff, the Special Court of Appeals remanded the case. They didn't say that there was no violation. It was simply a remand to analyze the issue in accordance with the very reasonable and rational statutory scheme. And for those reasons, I strongly oppose this duplicative and unnecessary and, in fact, statutorily inconsistent bill. Thanks.
Are there questions for this witness? All right, seeing none, thank you very much. That concludes the testimony for House Bill 402. And we will now, that Delegate Stewart is here with us, I think we will go to House Bill 128. And let's see what we got. Okay, there are 1, 2, 3, 4 people set to testify, including the delegates. The Delegate Stewart will go for 3 minutes. Then everybody else, the other 3, Sarah Mikey, Meredith Weisel, and Haifa Mohammed will each get 2 minutes. All right, so Delegate, for 3 minutes, here you go.
Thank you, Mr. Chair, Madam Vice Chair. For the record, I'm Delegate Vaughn Stewart, and this is HB 128. As this committee knows all too well, hate crimes are on the rise both nationally and in our state. This bill, HB 128, was introduced in a slightly different way last year. You heard it. It passed the Senate unanimously, but there wasn't time in the shortened session that we had to get it out of the House. We worked on a few changes over the interim, and a few amendments to strengthen the bill and to extend it. And so I just want to walk through those changes. The amended version would basically do 2 things. First, it would allow judges to sentence hate crime offenders to an anti-bias curriculum. This restorative approach has proven successful in a bunch of different places that have tried it. So, for example, a San Diego program of more than 60 youth offenders went through an educational program, and then after some brief follow-up, none had reoffended. A New York juvenile diversion program had a similar success rate, and a German program yielded a recidivism rate of about 25% compared to an 80% recidivism rate for comparable offenders who didn't complete the program. So basically, it works when done well. This training curriculum in particular would be created by the University of Maryland system, which has experience creating similar frameworks. We've talked to them and they've helped us craft some of the amendments that are before you. The second thing the bill would do is conform current state law to current legal definitions of gender and gender identity. This part of the bill is new. It wasn't in last year's bill. Gender identity is arguably already included within the hate crime law, but it is currently subsumed within the definition of gender and within sexual orientation. So this bill, this part of the bill would formally enshrine gender identity into the statute so that it's no longer up to legal interpretation. In conclusion, our current system is simply not deterring future hate crime incidences as effectively as it could and as effectively as some other jurisdictions are doing. Unless we attack this problem at its root and we get offenders when they're young and we teach them about anti-bias and about their own biases, we'll be facing many more instances of hateful acts and many more instances of pain and of trauma. So I urge a favorable report on HB 128.
Okay, next for 2 minutes will be Sarah. Are you here? Where are you? There you are. Go ahead, Sarah Mike. Go ahead.
Good afternoon, Chair Clippinger, Vice Chair Atterbury, members of the committee. I'm Sarah Mirsky-Mickey, the Deputy Director of the Baltimore Jewish Council, which represents the Associated Jewish Community Federation of Baltimore and all of its agencies. I'm here today in support of HB 128, Criminal Law, Hate Crimes, Protected Groups, and Penalties, which would allow a court to require those convicted of hate crimes to undergo educational courses created by the Board of Regents. It would also clarify that gender-related identity or expression are protected under the hate crime statute. Like everyone else testifying today in support, the BJC is concerned with the ever-increasing amount of hate in this country and in this state. A white supremacist who stormed the Capitol with Nazi apparel and t-shirts that said 6 million was not enough, to the increasing amount of swastikas found spray painted in Baltimore and other parts of the state, including an incident from just the other night. According to the 2019 State of Maryland Hate Bias Report by the police, which is highly underreported, Maryland experienced an average of 386 hate bias incidents each year from 2017 to 2019. There were 10 more incidents reported in 2019 compared to 2018. Of verified incidents in 2019, 17% were related to physical assault of the victim, with anti-Black followed by anti-Jewish making up the majority of total incidents. These incidents were reported in all of Maryland's jurisdictions. While these numbers are shocking, we do believe that education is key. Educating those who've been convicted of hate crimes about the group or groups of people they acted against has been a proven tool in changing attitudes, hearts, and minds. And for these reasons, we ask for a favorable report of HB 128. Thank you.
Meredith Weisel.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. Just for the record, again, I'm Meredith Weisel. I'm one of our senior associate regional directors with the ADL, the Anti-Defamation League. We're here, just like we were last year with Delegate Stewart, to support House Bill 128. I think a lot of the comments have been reiterated that Sarah noted, and you have my written testimony. A couple of things that I do want to highlight, though, and the reasons why we support this. So first of all, ADL is one of the leading providers of anti-bias education. We work with kids from kindergarten all the way through 12th grade and also on college campuses. And we have seen the value of an anti-bias education and how training can work and how it can be important for those, particularly when you're talking about hate crimes and those on the misdemeanor level, when you've seen something along the lines of somebody putting up a swastika or making a racial slur. Along those lines, there, as Delegate Stewart noted, the recidivism rate and how, things like this can continue. It's important that education and that we continue to talk about anti-bias and what that means so that we can stop. ADL has one of these things we call the pyramid of hate. And things don't start necessarily with a murder or assault or along those lines. They start with stereotypes. They start with racial slurs. And it's important that we catch that in the beginning. We catch things like vandalism and graffiti when it's been out in the community. And one of the things that's important, as Delegate Stewart noted, is developing a curriculum. And it's important that in light of the unique harm that we see hate crimes can cause, it's so important that the community most impacted knows that the legislature is behind them, knows that educational programming can help benefit the offender in the aftermath of a hate crime. For all those reasons, we believe that restorative justice and programming for hate crime offenders does remain discretionary because it really needs to be up to the judge to work and to see if it's the right approach on a case-by-case basis. But we do think that it's going to empower the community to play an important role in recommending programming that may not only benefit the perpetrator, but also as the community makes them feel to the greatest extent possible whole again. So for these reasons, we ask for a favorable report on House Bill 128.
Saifa Muhammad.
Thank you, Mr. Chairman, Madam Vice Chair, and House Judiciary Committee members. My name is Zaifa Mohammed, and I'm the Government Affairs Intern for the CARE Office in Maryland. On behalf of the Council on American Islamic Relations, I just want to thank you for this opportunity to testify in support of House Bill 128, entitled Criminal Law, Hate Crimes, Protected Groups and Penalties, sponsored by Delegate Stewart. The Council on American Islamic Relations is America's largest Muslim civil rights and advocacy organization. Its mission is to enhance the understanding of Islam, protect civil rights, promote justice, and empower American Muslims. Hate crimes in the United States have reached an all-time high in over a decade. This means that there are significantly more victims and survivors of criminal offenses due to their race, religion, ethnicity, age, and gender than there were 10 years ago. Hate crimes are a malignant outgrowth of prejudicial thoughts and beliefs which have no place in today's society. Unlike other violent crimes, hate crimes are often motivated by ignorant, misguided beliefs about a particular group of people. Anti-bias education involves creating an awareness of human differences. It promotes diversity, improves relationships, and teaches the harmful consequences of hate and bias. Such a training will help reduce the prevalence of these types of crimes by addressing the prejudicial thoughts and beliefs that fuel them. The Council on American Islamic Relations supports this bill because it addresses the root cause instead of simply resorting to punitive measures. We believe such measures will help discourage hateful behavior in the future, and therefore we respectfully urge your vote in favor of it. Thank you.
All right, are there questions? Making sure I'm not forgetting anybody. Are there questions for the panel? I think I am. I'm not. Questions for the panel, Delegate Williams.
Hi, sorry, I feel like I have a lot of questions today. So the one question that I have, I'm actually generally supportive of the bill with the gender identity provisions and definitely the courses. I guess the one question I have is about the age and why age is being added as a protective class. I mean, we've heard a lot of talk about a lot of other types of hate crimes, but I guess I'm just not really clear about the age portion of it.
Sure. Thank you, Delegate Williams. So in an earlier draft, when we were trying to get this pre-filed, we included age because we had heard from a limited scope of advocacy organizations who said that Maryland was one of only, maybe half of states that didn't include age. However, after talking with more groups, we've actually come around to what appears to be your view, which is that age has no place in the hate crime statute. It's not meant for those sorts of categories. And so one of the amendments you have before you is to strike age. And that's why I mention it, because as far as we're concerned with the sponsor amendments, it's basically no longer in the bill.
Okay, thank you. I appreciate that. I didn't see the amendment in my system, but I appreciate it. And also, I was just kind of thinking, I know with fair housing, one of the categories is familiar status, which sort of deals with age, but not directly. So I wasn't certain if that's where you were going with this, but since you're amending it, I guess it's irrelevant. So thank you.
Yeah, I appreciate the opportunity to clarify that point.
Are there further questions for this panel? Seeing none, thank you all very much. That'll conclude the testimony on House Bill 128. That one, we've done that one, and we've done that one. We only have 3 bills to go. What will we do? All right, let's go. What is the next bill? Next bill is House Bill 131. He's back again, committee. Delegate
everybody.
Again. And there's one, 1, 2, 3, 4, 5, 6 in favor and orally testifying. So we're going to go, I think we'll just hear from everybody. I think that'll be easiest. So that'll be the delegate for 3 minutes, Jazz Lewis, Mudib Lorsabi from Disability Rights Maryland, then Rick Van Wickel, Linda Moyd, Kay DeHaven, and that may be Kim Haven, actually, now that I look at it again. If that's Kim Haven, well, that's Kim Haven. All right. Joan Shreve and Brandon Rubin. 3 minutes for the delegate, 2 minutes for everyone else, and let's go right ahead. Delegate Lewis.
Mr. Chair, just want to say it's Neeb for him too, for when he gets called on. Thank you, Chairman, Vice Chair, and members for your time. Support of House Bill 131. We've all seen the devastating effects that COVID-19 has had in our community and across our state. I've come year after year to talk about solitary confinement and its effects on our community. And this year is going to be like no other. I'm going to come back again. We've taken a strategic approach each year, trying to address different factors of it. And this bill is focusing on those who are transitioning out of incarceration. 95% of the people who are incarcerated come home. Those who are in general population are allowed to participate in a step-down program, which helps them transition back into their communities. Think about things like securing housing, jobs, and reconnecting with their families. Things that are critical for them to be successful upon reentry. Too often, those who are in solitary confinement don't have access to these. Now, let's make no mistake, these folks are coming home, okay? So limiting the ability for them to have access to the step-down program is only creating a revolving door, because if they don't get the support systems they need, too often they come back. And we know this and have data to support it. So, you may hear from the department, he'll say, well, we don't need this because we provide the program, step-down program to everyone. Well, you'll hear from a number of the other folks on the panel, whether that's Munib or Kim Haven and others, of how that's not happening currently, which is why we have the bill to make sure that they can't prohibit them from access to the step-down program. And frankly, it's a safety issue. It's a safety. Can you imagine being locked up for weeks and years at a time, not being able to see or interact with other people appropriately, and then being released to the public? You're not going to be properly socialized. The other thing, for those who are new to the committee, may hear, I use the term solitary confinement. The department may say we don't do solitary confinement because we use restrictive housing, which is semantics. We, instead of placing someone alone in a room the size of a parking spot by themselves, we will place 2 people in that spot for 22 hours or more a day in the size of a room that's a parking spot. Okay, so, it's essentially semantics, but equivalently the same thing for those who go through it. I'll stop there. You all have my written testimony if you want to see all the data and figures. But since I held you guys longer before, I figured I'd keep it short this one. Thank you, Chair. You're muted.
All right, Munib.
All right, good afternoon. Thank you, Mr. Chairman, members of the committee. My name is Munib Larosby. I'm a human rights attorney with Disability Rights Maryland. We're the protection and advocacy agency for the state of Maryland with a federal mandate to monitor conditions and advocate for the rights of people with disabilities in state correctional facilities, all state facilities, really. But our work in prisons is focused on the inherently harmful practice of restrictive housing, which, as Delegate Lewis mentioned, is any housing status that keeps folks confined in cell for 22 hours or more per day with or without a cellmate. And that's a definition that's supported by a consensus of research that shows that the time in cell is really where the risk of harm comes from, whether you're putting someone, a cellmate in there or not. This restrictive housing can lead to increasing symptoms such as paranoia, anxiety, depression, hallucinations, and unfortunately, even self-harming behavior sometimes. The most seriously impacted group is the folks with serious mental illness, because existing symptoms of mental illness do get exacerbated. Our work involves regular communications with incarcerated individuals, record reviews, and facility visits pre-COVID. But these experiences all really support the research that I just mentioned. And the record reviews do show that folks in restrictive housing do display all of these symptoms, and that they do become worse and more exacerbated, and the behavior becomes more erratic as they spend more and more time in restrictive housing. The problem is compounded by the lack of mental health services or programming for folks in restrictive housing to mitigate the risk of harm. There is very little, if any, out-of-cell programming. The extent of programming that the department will talk about is typically a worksheet that's completed in cell. Out-of-cell programming in general is nearly non-existent, but that has become even worse with COVID, given that DPSCS's primary COVID response in multiple facilities was simply to lock folks down in restrictive housing conditions for months at a time. DPSCS, I would argue, barely prepares folks to transition back to general population, let alone back to the community, where folks may need to find a job, housing, or manage personal relationships. It's clearly a much more difficult transition than in population. So for these reasons, and because of DPSCS's failure to mitigate the risk of harm to folks in restrictive housing, Disability Rights Maryland does urge this committee to provide a favorable recommendation to House Bill 131.
Thank you. Thank you very much. All right, Rick Van Wickle, please, for 2 minutes. Wickler.
Thank you, Mr. Chairman, Madam Vice Chairman, and the Honorable Committee. For the record, my name is Richard Van Wickler. I'm a retired correctional superintendent. I've been in corrections for 32 years. I served 27 of those years as a correctional superintendent for the Correctional Department in Cheshire County, New Hampshire. I also represent today the Law Enforcement Action Partnership, which is an international law enforcement speakers bureau. I support this bill for the following reasons. The intent and the spirit of House Bill 131 is consistent with the recommendations, the guidance, the study of the Substance Abuse and Mental Health Services Administration, also the National Commission on Correctional Healthcare, the United States Department of Justice, the American Correctional Association, the National Institute of Corrections, and the Bureau of Justice Statistics, all of those agencies that provide us guidance and the standards for which we conduct our business in corrections, or at least we should. These agencies would agree that it is unacceptable. It's unprofessional and systematically condones the failure of the system to release an offender directly from segregation or isolation into the community without case management, interaction, or connection to programmatic services. Inmates need an opportunity to have that programmatic handshake for a successful reentry. The American Correctional Association takes the position that American offenders, they say inmates are not in jail to be punished in this country. They are in jail as punishment. And so our role of providing safety for the public and a means of punishment for our judicial system requires that we are aware of and engage in the best practice of managing human behavior at all times, and especially sometimes that of aggressive human behavior. This should be achieved with intellectual training, professional practice, and not left to the instinct and survival nature of overworked correctional staff and administrations. Our correctional goals should have a sober and responsible application by our correctional practitioners and require the full support of its administrations and our legislatures. I encourage the passage of this bill, and I appreciate the opportunity to share my professional opinion on the matter at hand today. Thank you very much to all of you for your service to the American public.
Thank you. Ms. Moyd, please.
Good afternoon, Chairman Clippinger and Vice Chair Atterbury. Greetings to my representative, Mr. Ron Watson. The Maryland Alliance for Justice Reform supports a favorable report on this bill. I chair the Behind the Walls work group for Major, the organization, and so I received the letters and phone calls from the men and women who are behind bars in Maryland, and I know that many of them support this bill. As a prisoners' rights attorney, I have had the unfortunate experience of witnessing the devastating impacts of long-term placement of human beings in restrictive housing. One critical component of this bill is to mandate the step-down process so that individuals are not just thrown back into general population or thrown out into the community without having gone through this process. The process would be guaranteed for every person 180 days prior to release, and it would include things that are spelled out in the bill, pre-screening and monthly evaluations, most importantly, integration of human contact. Solitary confinement is often overused by staff, especially for persons that they deem to be problem or difficult individuals. Reports from the Sentencing Project and from Yale Law School indicate that Black men and women are disproportionately impacted by the overuse of solitary confinement. Juveniles and those who suffer from mental illnesses are also often placed in solitude. No person should directly be released from restrictive housing to the community. And I would just remind everybody about the story of Khalif Browder, who served 3 years at 16 years old in Rikers Island. 17 of the months before he was released, he spent in solitary confinement. 6 months after his release, he made his first suicide attempt, and eventually he succeeded. And his family contends that solitary confinement is what destroyed him.
Thank you, Ms. Floyd.
For these reasons, we support the bill. Thank you.
Thank you, Kim Haven.
Good afternoon, Mr. Chairman, Madam Vice Chair. Again, Kimberly Haven. I'm here today in support of House Bill 131. This legislation has come before this committee before, and last year this committee supported it. We're talking about upwards between 250 and 300 people every year get released from our public safety institutions back to the community. This is a straight up public safety threat. There is no transition. The department will say that they do this. They don't. We know when these people are going to come home. And as Mr. Van Wickler said, there needs to be sort of this handshake kind of arrangement where things are set up prior to someone's release. Because we know, as Ms. Moyd said, and she referenced Khalif Browder's brother, that at the end of the day, when people have spent long time in solitary confinement, when they come home and they've been inadequately prepared to return to the community, they do one of two things. They will either reoffend, so they go back inside because it's the environment that they know, or they will what we call Shawshank, and they will kill themselves. And that happens all too often. Sorry, my dog wants to testify too. But the other thing, and probably one of the most important things that I want to share with the committee today to show the importance of why this is just so critical to do this year. I got a phone call from a gentleman who was incarcerated at age 17. He did 22 years inside. He was told not 180 days before he was going to be released. He was told 4. He had nothing set up. His cellmate said, "You can go stay with my wife." Red flag number 1. That did not work. He came home and he was told, "Here's your probation agent. This is who you need to call within 24 hours. He called for a week. He finally got a hold of me. We talked to a supervisor. That agent hadn't worked there for months. This man was set out on the street without any preparation. He didn't know how to use a smartphone. He still was on landlines. He doesn't know how to use an ATM. He was unprepared, and he was released without documentation. The idea of a transition and a step-down program is absolutely critical for every single person, but specifically,
Ms. Haven?
Yes, I support 131 specifically for people that are in restrictive housing. Thank you very much. You'll hear from me again.
Of this we are certain. With no problem with that. Just trying to stay on time. Joan Shreve.
Hi, good afternoon, Chair Clippinger and members of the committee. Again, I'm Joni Shreve, social worker from the Maryland Office of the Public Defender Post-Conviction Division. The Maryland Office of the Public Defender respectfully requests that the committee issue a favorable report on HB 131 to establish a step-down program for individuals who have been placed in restrictive housing. I work with individuals who are serving sentences in Maryland prisons and help prepare for release. I've reviewed many institutional records, including incidents of misconduct and experiences in segregation. Segregation may be used for multiple reasons, not just disciplinary actions, but regardless of the reason, it can have lasting effects on physical and mental health. I have not, in my experience, seen step-down services offered to my clients in institutions other than at the Patuxent step-down program for people who have destabilized at their home institution. The transition process before release is key in setting up individuals for success outside of prison. Restrictive housing can have, like I said, long-lasting permanent effects, and even if that amount of time in segregation is for a short amount of time. Time in restrictive housing is associated with higher arrest rates post-release, higher rates of self-harm, and suicide. The experience exacerbates existing psychiatric symptoms and can negatively impact those without prior psychiatric symptoms. Addressing the underlying needs and behaviors produces positive results and reduces the harm experienced in isolation. If segregation is used, it is necessary to create opportunities to ameliorate the harm caused and provide support. Without an individualized transition plan before the return to general population or to the community, individuals are denied an opportunity to develop and maintain skills that will help them succeed outside of prison. For return to the community, the best practices include creating release plans, offering psychoeducational courses, group therapy, and social interaction, and providing what we call warm referrals. That handoff is better when you can do intake and create and have opportunities set up prior to release. So for those reasons, the Maryland Office of the Public Defender urges a favorable report of HB 131. Thank you.
All right, I don't see Brandon Rubin.
I'm representing the Office of the Public Defender today.
You were being Brandon. All right, that's fine.
Yeah.
Okay, so with that, that was the final bit of testimony. We'll go to questions now. And we'll start with Delegate Arakan, and then I see Delegate McComas.
Thank you, Mr. Chair. Thank you, Delegate Lewis. I was hoping you would bring the tiny Delegate Lewis today, but I see you failed me completely. So I have two questions. One is, could you update me again on what happened last year? We had a similar bill, right? And what were did we vote on it? What happened with that? And then if this bill had been in place during COVID, what would have been the impact when we started to release people? Like, because they basically use solitary or whatever it's called to quarantine people. So almost everybody essentially would probably fit this new definition. So how would we then be because a ton of people got released because of COVID. Mm-hmm. What would have happened? What would have been the impact of this bill if it had already been in place? Those are my
So if it's okay, I'll answer the first part, and I'll leave it to my panel to answer the implications between, Munib, Richard, who did this in another state, and Kim, and then they can answer that. Miguel's first day at daycare was today. That's why he's not here.
Oh, I hope he does well.
I was very happy, as well as Papa. So 2 years ago, we passed this bill out of the House. And it died on the Senate floor. It got special ordered to the day after session by one of our colleagues who, we're really nameless right now. But it passed out of our committee, is the point. Last year, it didn't pass out of our committee only because time ran out. We were working with the department, and the chair was very helpful with that. It was going to, but we just ran out of the clock like so many bills did. So that's where that is. I'll leave the panel to answer the second question.
Delegate, could you rephrase your second part of your question, please?
Sure, yeah. If this law had already been in place at the beginning of COVID, how would that have impacted sort of the way we quarantined people, potential infection spread, and then how we release people, since I think they would be, technically, it would qualify under the way this is the wording of this, that pretty much everybody was in solitary for quarantine purposes. So what would the impact have been had this already been in place?
Had this already been in place, I think that, and Munib, I'll ask you to talk from the mental health perspective. It would put the department basically on the front lines to do what they say that they're doing, which is preparing people for release on a daily basis. And so with COVID, this gentleman had a COVID that I referred to in my testimony. He had a COVID test 2 days before he was released. He was never told what his results are. And again, we're talking about prisons as being a petri dish for COVID and with our officers and with our incarcerated population. We're letting people go without properly transitioning them back. Also from solitary restrictive housing, again, it's a game play that public safety plays back to the general population. It just keeps that vortex going. We know when people are going to be released absent court releases, which just kind of throws everything out the window. But we do know people's release dates. And so we can do better and we must do better to transition people from restrictive housing back to general population or back to the community, absent exigent circumstances. We're not talking about everybody because I know that comes up. But I think that it's critical to understand that more than 15 days in restrictive housing is considered torture. We've now been in a virtual lockdown status for 11 months, and we're still releasing people without, as I referenced the gentleman that I'm working with, this is how we're releasing people. This is unacceptable. And as Mr. Van Wickle said, this bill is in keeping with what the National Institute of Corrections and the American Correctional Association says. So we are in line. We are not asking for something that is not already in use and is not already considered best practices.
Yeah, I get that part. My concern, I think, is how in that type of environment, if this bill was in place and they essentially wouldn't be able to quarantine people. So what are we anticipating that like coronavirus is just going to spread and that's okay because it's better to not lock people into separate areas? Or, I mean, what is your ideal, like, if things could be perfect, how would you have handled COVID in the prisons if we're saying what we've done, which is isolate people, is unacceptable, we can't do that? What is the thing that we should have been doing that's better than that?
Delegate Erickson, if I could just step in here. So I do think that, first of all, this bill calls for transitional services, not just out of cell time, right? And a lot of that can be done remotely, correct? And then those transitional services are helpful for everyone. We think this bill is just addressing folks in restrictive housing, and we do think that they're a group that needs it, more than others because of the conditions they're in. But if we're just providing those services for a larger number of people, we don't necessarily see that as a negative thing. In fact, that would reduce recidivism and improve public safety across the board for a larger group of people. In terms of the out of cell time specifically, that also could be accommodated in smaller groups. COVID and what CDC guidelines, I'm not Dr. Fauci, but what I recall the guidelines are is groups of 10 or more, correct? So you could still do the out of cell time in shifts, perhaps, of smaller groups. You obviously could not do recreation or programming or out of cell time in the same manner that it was conducted pre-COVID, but there are absolutely accommodations that can be made to do programming either remotely or in smaller groups.
And Delegate Erickson, you asked a question about what should we have done? What could we have done? When there's a snow emergency, the snow emergency system is initiated and everybody knows their job, where they're supposed to be. We were unprepared for a pandemic. We should have had a pandemic policy in place. And immediately, we need to make sure that every single incarcerated person, every staff person has a routine and regular supply of PPE. They do not have PPE currently. There is not an opportunity for them to sanitize their areas or social distance. And so there's no wonder that this is a petri dish. We know that incarcerated individuals are given one mask when they come in, one mask. If you've got a sentence of 5 years, what are you going to do with that one mask? They're making masks out of makeshift things. We're hearing sailcloth. We're hearing uniforms. None of these are going to prevent the spread of COVID behind the fence for staff or for incarcerated individuals. We also know staff isn't following the COVID protocols. We hear this every single day. So what we should have done, what we could do, we still could do this. We need a pandemic policy, but it's going to take legislative pressure on the department to make them do the right thing, not just for our incarcerated population, which 95% of the people are going to come home, but also for our correctional staff and service providers that work behind the fence.
Okay, thank you very
Okay.
much, Mr. Chair.
Thank you. Could we go to Delegate McComas, please?
Thank you, Mr. Chair. Just to any of the panelists, are there any other states that you feel are the best template for providing a step down for people that have been in isolation or restricted custody in the prison system? And then the second question is, I assume that there's been some studies that maybe you could give us the links to, showing what happens when people are literally, they're let out the door from restricted isolation or whatever, and they say, hey, you know, you're free now, and walk out on the door. Because I'm sure there's probably some good research on that and the problems that have been caused because of that. So that's it. Thank you, Mr. Chair.
I'll let Munib and then Mr. Van Wickle answer your question, but I will get those studies to you, Delegate McComas, and the rest of the committee.
I think Ms. Moyd was about to.
I was just going to say that I did mention a report from the Human Rights Council in my written testimony. And in that report, they support the implementation of many of the step down protocols that are included in this bill. And so that is one report that you would want to take a look at. Thank you.
And just speaking generally, Delegate McComas, we believe that Colorado and Pennsylvania are two states that certainly have led the way in terms of their use of restrictive housing, and would direct you to look at those models.
All right. Thank you all very much. I believe those are the final questions on the bill. Thank you all very much. That concludes the testimony for House Bill 131. We're going to move on now to House Bill 316 and Delegate Stephanie Smith. There are quite a few people to testify. 1, 2, 3, 4, 5, 6, 7, 8, 9. 9. All right, there are 9. City Council President, House Bill 316, and Delegate Stephanie Smith. Mr. Yes, he is. All right, so here's what we're going to do. We're going to do, Delegate Smith, you're going to get 3 minutes. I'll say this again because he's connecting to audio. We'll go first witness will be to the City Council President immediately after Delegate Smith, who will get 2 minutes. Then we'll go Iman Freeman, Matthew Zernhelt, and Trayvon Johnson. Then we will take questions before going to Nicole Hansen, Christopher Dews, Todd Oppenheim, and Dwight Kearney. Okay, so for 3 minutes, Delegate Smith, please.
Thank you, Mr. Chairman, and also thank you to Vice Chairwoman Atterbury and distinguished members of the Judiciary Committee. I don't get to spend too much time with you guys, but I'm excited to be before you with House Bill 316. This bill is concerning home detention monitoring and the costs related to them. Under this proposal, which is similar to a proposal that you heard in the 2020, if a pretrial defendant is found to be indigent, or otherwise eligible for representation by the Office of the Public Defender, or the state or local jurisdiction provides the private home detention monitoring device or the GPS device. In those instances, that pretrial defendant would not be required to make the payments related to that service. As you'll hear from some of the other testimony from others, this is essentially a situation where you have not been convicted of anything, you're a pretrial defendant, but because of your financial circumstances, you may very well need to remain in custody. And in light of the environment we find ourselves in with COVID, we definitely do not want people inside of our various detention centers unnecessarily. If we can provide a mechanism that's not only safer It's more affordable. It's actually cheaper than keeping them housed. And also, this is about preventing the criminalization of poverty, because at this point, the pretrial defendant has not been convicted of anything. And in many ways, just the absence of financial support is preventing them from being able to be sentenced safely to a home monitoring situation. So we know that various localities in our state do provide some of these pretrial services at no cost, but this is not a uniform policy across the state. And we feel that a pretrial defendant, no matter what corner of the state they're in, should, if they meet the circumstances outlined in House Bill 316, they should be able to have pretrial home detention monitoring services provided to them without cost, so that they can be safe, so that they can also not, they can save some money because they won't be housed. And then also ultimately they can be in a more supportive environment as they navigate the next steps in the process. So I know that there's a lot of people with a lot more details about the per diems, what these costs look like for people that are indigent and the obstacles they can pose. So I want to give others the opportunity to really paint the picture and really add a face to what this looks like, because ultimately, we don't want to be a state known for policies that essentially criminalize poverty, and this is but one. I believe that this bill is a first step as we continue to rethink, reimagine, and overhaul our pretrial detention landscape. And I do welcome any strengthening amendments that folks think could happen in this instance. But I do want to bring to everyone's attention that there has been one amendment filed, and this is simply to move up the implementation deadline from October 1st to July 1st, because in light of the pandemic, we believe it's in the best interest of public safety to have this law, should it go into effect as quickly as possible. I do thank you for your time and request your support for House Bill 316. Thank you so much, Mr. Chair.
Thank you, City Council President Mosby.
Thank you, Mr. Chair, Chairman Clippinger, as well as Vice Chair Atterbury and members of this distinguished committee. I'm President Nick Mosby, Baltimore City Council President. As you guys are well aware, this is a bill that I have championed over the past couple of years. Thank you for your hard work in getting this bill out for the first time last year, and I'm excited to support Delegate Stephanie Smith of the 45th District this year. Delegate Smith framed it up perfectly. She talked about the idea of going after criminalization of poverty, and that's exactly what this is. This bill came to me when I met with individuals who were morphing away from the bail bond industry. A industry that this committee took on its head, an industry that was fighting and fighting and fighting to keep the current practices in place, but an industry that this committee ultimately decided to move in a different direction. And many of the owners from the bail bonds industry shifted to this business because it was a business that was cyclical, just as the bail bond industry, meaning that you had individuals and their families trapped behind some of these contracts that provided issue associated with that individual's freedom. And people were willing to do almost anything to try to pay and to stay up on these particular bills. But as I continue to dig into the issues around it, we were able to identify there's no regulation or activation, the monthly costs, and the onerous expense that's placed on an individual just to provide their freedom. If they had the money, they would be free. If they do not have the money, they will not. Well, I think it was the motivation and the posturing of this council, of this committee to determine that criminalization of poverty is not something that we need in the state of Maryland. And I was really relieved and thankful of your hard work that the committee played last year. So again, I'm asking for your strong support in this measure. I think the timing couldn't be better, and I'm happy and pleased to support Delegate Stephanie Smith.
Thank you very much. We'll go now to Iman Freeman.
Thank you, Chair Clippinger, Vice Chair Atterbury, and members of the Judiciary. Between March 1st, 2020 and January 1st, 2021, Baltimore Action Legal Team has paid over $100,000 to 2 private home detention companies in the Baltimore area. We took on clients who could not afford to cover the cost of court-ordered home detention monitoring. If BALT had not raised these funds, 131 Baltimore residents awaiting trial may have remained in jail during a global pandemic awaiting their day in court. Let's be clear. People are being required to pay for the state to monitor them during a global pandemic and while people are losing their jobs every single day. This is the very definition of criminalizing poverty. Currently, with indefinite court closures, postponing trial for a year or more, a person could potentially spend over $4,000 in fees. At this time, we ask that our least marginalized community members be given the protections of our founding principles and urge a favorable report on HB 316 from this committee. Thank you.
Thank you very much. Matthew Zernhelt.
Thank you. Matt Zernhelt, Legal Director with Baltimore Action Legal Team. The Supreme Court has held for almost 30 years that treating criminal defendants differently based on wealth is a matter under the Equal Protection Clause, denying indigent folks who the Supreme Court has deemed a protected class a substantial benefit available to another class of defendants violates the intended principle of fairness, Bearden v. Georgia. The Supreme Court has also held that once the presumption of innocence has withstood all challenges of the state, the defendant must get their fines and fees back. This bill would be the closest we have come to adhering to that holding, Nelson v. Colorado. This is also not a matter of a few folks falling prey to unwarranted fees. Looking at a sample of over 4,000 cases from 2018 and 2019, with charges no higher than second-degree assault that were held without bail during at least one of their bail hearings, so a fair sample of the pretrial population. We found that 73.3% of those cases had all of their charges dropped. So almost three quarters of the pretrial population that are getting put up for electronic monitoring aren't even having their cases sustained. So we railroad lives for cases that don't even have merit. As an apparent next step on our way to tiered community release, I urge you all to please support this bill. Thank you so much, Chairman.
Trayvon Johnson for 2 minutes, please. Mr. Johnson.
How you doing? Can everybody hear me?
Yes, go ahead.
All right, how y'all doing? My name is Trayvon Johnson. I was invited here by JOTF. I'm currently on ASAP home detention, and I'm here to speak in favor of the House Bill 316. During my bail review, for charges that have already been dropped, the judge offered me the option of home detention with the box or waiting in jail. As jail is extremely unpleasant place. Of course, I took to come home. What was not explained properly to me was how much going home would cost. ASAP home detention, the monitoring company charged me $240 up front and told me that I would have to pay the minimum of $70 every week or risk incarceration. This was horrible because I didn't have the money. If it wasn't for JOTF, I would be incarcerated right now. The judge had not told me about this, and I thought this service used to be free. It made no sense to me that during the pandemic, when people are hurting, that they are charged people $280 a month just to stay home. I explained to ASAP my concerns with the cost and was threatened by the staff to sign the papers or go to jail. When I asked them to explain the documents before I print my signature, they repeated themselves. They told me that I can go back to jail in rude and disrespectful ways. And they are taking advantage of the moment to charge recklessly high fees. I worked out a deal with my lawyer who split the $240 up front. But my bad, Your Honor. But I shouldn't have had to pay anything. The upfront cost and the following $280 per month even exists is a serious problem. There is no pretrial monitoring costs in Montgomery County, and I firmly believe that the entire state should follow their footsteps, especially for those who don't have no money to pay for their freedom. No one should risk going to jail because they can't afford freedom fees. House Bill 316 will go a long way towards fixing this situation for myself and hundreds of others in the struggle right now and in the future. For these reasons, I urge a favorable response, and I hope that y'all pass this law.
All right, thank you, Mr. Johnson. We'll go to questions now for this first panel. Delegate Deborah Davis, please.
Thank you, Mr. Chair, and I'd like to commend Mr. Johnson for his testimony. My question is for Iman Freeman. Notes, and my question is, what were those figures again, and were they all for pretrial services?
Yeah, so right now we've expended close to $150,000 since March 2020. And yes, everyone is pretrial.
All right. Are there further questions for this first panel? Seeing none. Delegate Conaway, are you asking a question? You would like to ask a question? There we go. Delegate Conaway.
Thank you very much, Mr. Chairman, Vice Chair. My question is anyone familiar with how often this happens where you have an incident like Mr. Johnson described? How often does that happen? Is this an unfamiliar topic where he says his charges were dismissed, but in order for him to be free, he has to pay for home monitoring, or it's just typical? I mean, any of the people who would testify, no.
Are you asking if and when a person finally does go to court, the outcomes usually result in dismissed charges, even after they've paid hundreds of dollars to the private detention company? That's very common.
Well, what I think he was describing was that his charges were dismissed before he had the private monitoring. Is that correct?
No, that's not correct, sir.
Oh,
my charges been dropped afterwards.
After you had the detention.
Correct. So you're
Yes,
paying
sir.
while you're waiting
Okay.
for a corporate outcome.
All right,
My
I understand.
bad.
Thank you so very much.
And the Supreme Court has said that charges paid to the state, once your presumption of innocence has been sustained, the state has to give you that money back. And arguably, by outsourcing these home monitoring companies, they are now an extension of the state. And the current apparatus that the state's using does not allow for that. So we need to change it to the Supreme Court's current holding.
So what you're describing is that the companies are supposed to pay the people back if the defendants are found innocent or the charges are dropped, but they're not getting their money back.
Well, I don't see this. I don't see the private companies doing that. But so I think to forgive the private companies, being put in that position, the state needs to be paying them itself. Or the state needs to be providing the services so the state can pay the people back if the state's actually going to charge it. But I think the state charging people, indigent or not, raises other constitutional concerns. But I think that might be, for next year, as we move towards, greater forms of hearing.
Thank you very much.
Are there further questions for this panel? Seeing none, thank you all very much. We'll go to the second panel. That will include Nicole Hanson-Mundell, Christopher Dews, Todd Oppenheim, and Dwight Kearney. Let's see, Nicole Hanson, Dews. None. Thank you all very much. And Mr. Oppenheim. And I think I saw Mr. Kearney, but okay, let's go with Nicole Hanson, please.
Good afternoon. My name is Nicole. Mr. Committee Chair, Vice Chair, and all the members of the Judiciary Committee. For the record, I am the executive director of Out for Justice, a nonprofit organization that is led by formerly incarcerated individuals that advocate for formerly incarcerated individuals, and had great privilege of working with Bolt Action Legal Team and the Job Opportunities Task Force at the height of COVID to support our individuals who have been impacted by home detention fees that they could not afford. When the state realized years ago that there were defendants who, through no fault of their own, other than their unfortunate financial circumstances, failed to have access to adequate legal protections, you all saw fit in your infinite wisdom to provide a public defender to represent those who were deemed indigent and therefore unable to afford such costly legal protections. This is merely an extension of those services, allowing for those otherwise who qualify for home detention monitoring fees to have the opportunity to wait their day in court in the confines of their home. I would argue that these pretrial service programs are established and administered based on a risk assessment scoring system that is supposed to take into account evidence-based, race-neutral factors. However, given the majority of those who qualify as indigent are the minority race in this country, then I would say that denying these men and women the opportunity to serve their time awaiting trial at home, like those with similar crimes and judicial backgrounds, further shows a racial bias system that continues to unfairly penalize these individuals based on their economic circumstances and not the evidence-based racial neutral risk assessments that's supposed to govern our society out this process. I would also add that in conjunction with the work that Bolt did, Out for Justice spent upward of $23,000 in funds that we had to raise to offer rent support to those individuals who had to pay those home detention costs. We had to offer direct food support. We had to offer childcare support to individuals who had to go to work. We had to help to pay the daily cost of living support to those individuals who were on home detention, could not afford those costs. And even some of our members, we had to directly pay the home detention costs as well. We all know that the Pew Research study in 2016 really estimated the cost of housing an incarcerated person.
Mundell, please, if you could wrap up, please.
Okay, I'll wrap up. I think what's important here is that individuals cannot afford these fees. And it would be more cost effective for the state to incur those fees, those home detention fees, as opposed to housing individuals in very bad conditions in our prisons and jails. And since I have not been able to finish out my testimony, that is what I would say, and hope some questions come my way.
You never know, these things happen. Christopher Dews.
My name is Christopher Dews. I'm a policy advocate for the Job Opportunities Task Force. Before I begin, I do want to say that I actually put this testimony in spot for Karen York, my CEO, and if she is actually in the waiting room right now, I don't know if we can push her in and then move me out. I don't know how you guys want to do that. I will defer that to the committee. Apologize for that confusion.
Good afternoon.
Generally speaking, we don't do that because we need people to, we're trying to keep some level of control. I will do it for Ms. York this time, but please, in the future, for those people who are listening, you got to sign up. You got to sign up yourself, because otherwise we can't. It becomes a lot harder for the committee and the committee staff to be able to keep up with it and keep up with everything. But I'm happy to hear from Ms. York. So please, Karen York.
Thank you so much, Mr. Chairman. Good afternoon. As CEO of the Job Opportunities Task Force, I am testifying in support of House Bill 316 as a means of continuing the unfinished business of eliminating a wealth-based pretrial system in Maryland that continues to penalize individuals who are poor and overwhelmingly Black. In 2017, JOTF and partners successfully advocated before the General Assembly to upload the landmark unanimous Court of Appeals ruling deprioritizing the use of cash bails specifically and financial conditions generally in an effort to reduce the number of poor Marylanders sitting pretrial due to an unaffordable cash bail. While more individuals are receiving less cash bails than before 2017, we are far from done. This is evident by the need for JOTF to establish the Community Bail Fund for Baltimore City, created in partnership with the OPD, Baltimore Action Legal Team, and Out for Justice, where initially the focus was on cash bails, yet over time, monies needed to be spent on both cash bails and home detention monitoring fees. Pandemic-related court delays saw more individuals assigned to home detention as covered by the Baltimore Sun and Washington Post in August and September 20th, 2020, respectively. The cost, as many of our panelists have indicated, is the responsibility of the defendant. We, JOTF, find we have to pay for both the monitoring fees of our job training program participants and literally beg to modify the detention rules to allow, and the monitoring rules to allow participation of our clients so they can meet court orders, which includes finding employment and paying the fees. To be clear, if the defendant defaults on payment, that is a violation of the home detention order. It is disingenuous and dangerous to imply otherwise. You've heard from our partners. You will hear from more individuals directly impacted by the system who will share similar stories. In urging a favorable report of House Bill 316, I ask the committee to remember that courts around the country, including our state's highest court, have established that pretrial conditions that are unaffordable and tied to one's freedom are blatantly unconstitutional. We started this long process in 2017. House Bill 316 is a step closer toward the goal realized recently in the state of Illinois, an end to wealth-based pretrial detention. We urge a favorable report. Thank you, Mr. Chairman, for allowing me to speak.
Thank you very much. Todd Oppenheim for 2 minutes, please.
Thank you, Mr. Chairman, Madam Vice Chair. My name is Todd Oppenheim. I'm a public defender. I'm a supervising attorney in the office of 17 years. I currently have clients on home detention, and I'm very familiar with the process. The Maryland Office of the Public Defender asks that this committee issue a favorable report on House Bill 316. We support the bill. No one awaiting trial presumed innocent should be incarcerated based on their financial circumstances. Maryland's piecemeal pretrial home detention system, in actuality, is no system at all. Yet it manages to keep individuals who cannot afford home detention in jail before being convicted of any crime. Many counties throughout Maryland depend on private companies to provide GPS monitoring for individuals awaiting their court date who are ordered by judges to be released with such restrictions. These services cost money. Some counties provide home detention services but charge fees. Simply put, if you cannot afford the home detention fees, especially in the jurisdictions using private companies, you cannot be released on home detention. Worse, if you're released and struggle to make home detention payments, you can be rearrested for violating the conditions of your release. In 2017, the Maryland Court of Appeals changed the rules of court to disfavor the use of cash bail and guide judges towards the least onerous conditions of release during bail review hearings. The net effect has been the overall decline in the use of cash bail. Consequently, the OPD finds fewer individuals stuck in jail pretrial with unattainable bails. To be clear, though, bail is still legal in Maryland. It's just less frequent. Along with bail, pretrial supervision, stay-away orders, curfews, and personal recognizance comes the possibility of release on home detention. Dorchester, Somerset, Wycomico, Worcester, Charles, Kent, Hartford, and Harford counties, along with Baltimore City, allow pretrial home detention, but require fees. This means that the judge can order someone released on either private or public home monitoring, depending on the place, but a defendant would have to pay for it. Neither the companies nor the public option will permit the individual to be placed on home monitoring without the ability to pay. So we see it as, I hear my beeping, we see it as a twofold plus here. First, it's a fix to the immediate problem and for several respects. It will provide quick financial relief. The second thing is that this is a window to more permanent pretrial reform throughout the state. This is an equal protection issue that preys upon people of color predominantly throughout the state. By doing this, you're essentially creating a system where counties that don't provide the home monitoring, there'll be funding for it. So for all these reasons, and we want an enactment date as soon as possible because this is obviously affecting stuff because of the pandemic.
Thank you, Mr. Oppenheim. Thank you. Dwight Kearney. Mr. Kearney, go ahead. He might be frozen. Oh, there we go. Dwight Kearney. I wonder whether he can hear me.
It shows his audio is working on our end.
Okay, Mr. Kearney, if he All right, well, we'll give them a chance to talk. We'll see if they'll, we'll see if others have questions, and then we can weave him in here. So I don't want to miss him, but that's fine. Are there questions for this panel? On the other hand, this will be the time that there aren't questions for this panel. Mr. Kearney, can you hear me? Dwight Kearney? We can't hear you. All right, he is having difficulty with his connection. Yeah, he appears to have difficulty with his connection. We'll give some time here, and Delegate Juanita Fisher has a question. Delegate Juanita Fisher.
Thank you, Mr. Chair. Sorry, I can never tell if my hand is staying up or not. I'm not sure who would be the best person on this panel. Maybe Ms. York, but are judges specifically required to do the private GPS monitoring, even in jurisdictions that have free-based alternatives there?
No, thank you for the question, Delegate Fisher. And I'm sure Todd will want to step in as well. But no, the requirement is not that they have to defer to the private companies. Unfortunately, what we hear is that it's just a lot easier for locals, and in those jurisdictions where the state runs the local corrections, it's a lot easier to work with the private monitoring companies because they in turn are the ones who are responsible for intake and the monitoring and the like, and the state and the locals would rather not or have rather not for that responsibility.
Yeah, to be clear, the list of counties I listed there, this is not just a city thing. This is all those eastern shore counties. They do not have a public option. So when a judge orders private home detention, that's the only option. So we have a conversation with our clients. Can we even ask for this? Is this even feasible? Most of our clients are, obviously are indigent themselves. The question is the family going to be forced to cobble together rent payments and put them towards home detention? Potential private attorney fees and put them towards home detention? Are they going to put together money that's going towards food and put it towards home detention?
Thank you.
Thank you. Can we let me go back, Mr. Oppenheim, to the counties that you were talking about. Again, walk me through Baltimore City again. So Baltimore City, run by the state, pretrial run by the state.
Yeah, it's a mess. So all of our jails are operated by the state. Our clients are housed in prisons. Let's not make a mistake about that. They're with people that are serving sentences. So the state not only manages the facilities, but they also control the pretrial services operation, which could potentially manage a home detention system. However, they don't offer it at all. So everything is privatized in the city. We can only deal with ASAP and alert. Those are the only options, and they're fee-based. There is, so I don't want to confuse things. There is an institutional option that was set up for people who are serving sentences who could be released on home detention. But that's few and far between. If our clients are even going to be eligible for that, they would be recogged by a commissioner to begin with, because the charges are so restrictive that you can even get that for.
So just to walk, hang on one second. Let me ask this just very quickly. I think sometimes people get lost in the pretrial and post-trial. So the state, and we've had briefings from DPSCS, has said a couple times that, hey, we are releasing people onto home detention. So they are paying for that, presumably, right? For the post-sentencing home detention, correct?
Yes, that is state-based.
And I don't mean to be dense about this. I kind of want to walk through a couple of things. So that's not the part we're talking about here at all. This is pre-trial. It is not post-trial. I got it. So the state doesn't offer anything along those lines. What county? I remember early in the pandemic, I may or may not have been on the Montgomery County delegation meeting with their Department of Corrections. They offer for free, correct? Montgomery.
Baltimore, you have Baltimore County, who not only offers it, but just waived all fees locally. You have Montgomery, who has their own pretrial free. You have Anne Arundel, who has a local one, I believe.
Aware of that one, yeah.
And then you have Southern Maryland, a tri-county area down by St. Mary's County as a model for that. And this goes towards what we can do with pretrial is make it more holistic. Believe me, home detention is not a goal of ours. It gets people out and it gets them free from a virus here. But home detention is not we don't want to privatize anything. A lot of these people don't even need monitoring, but if that's what it takes to convince a judge the community is going to be safe until the case eventually gets dismissed or a person gets probation, which is ridiculous for them to be in jail to begin with, then that's what we have to do for our clients.
Well, and going to be a little gratuitous here and not picking on Delegate Deborah Davis, but we've sort of had an ongoing running commentary between the two of us about pretrial in Charles County and its lack of its own existence, and lack of an existing pretrial there in Charles County. So I know that the sheriff, I think it's Sheriff American down in St. Mary's, has done a lot down in that part of the world with this. But the questions then that come into my mind are that of how does this work and who. I see that the requirement, and I'm now focusing. First of all, I did cut off Ms. Hanson-Mundell a moment ago, and I'll come right back there. But to anybody who can answer this, including the sponsor, if she knows, I understand that the qualification would be people would qualify for this if they qualified for the public defender. I guess how would the information get from the Office of the Public Defender to the agency? I'm thinking about counties that don't have a pretrial. There are quite a few that don't. And to your larger point, I do think there's an argument that needs to be made that there needs to be some kind of a state pretrial here and that we do need to move towards that. My question becomes, though, for now, who actually runs this? And I have a connected question to that. Who monitors the monitor who we're going to be paying for this? Because that isn't clear to me either. Who monitors whether or not the person is being is complying with the house arrest? And I see Ms. York, I think, was getting ready to talk. So we'll start there.
Right. I didn't want to, jump in place of Delegate Smith, the bill sponsor, if she wanted to answer.
That's all right.
But okay. But just very quickly, I think it's important to note that in terms of regulating the agencies, right? There's no regular, there aren't regular bodies or an oversight to ensure that predatory practices are not occurring. However, you have agencies such as the private home monitoring detention companies that are regulated or, quote unquote, supposed to be regulated and are regulated in our code under, I believe it has to do with our occupations article. And so in terms of regulation, Mr. Chairman, that's really the only kind of, oversight or regulation that we're speaking of, but it's not like the companies are, there's regular audits to ensure that, or, just regular check-ins to ensure that this isn't a practice that is actually working against many of the policies that the state of Maryland has either adopted or is trying to move in the direction of.
Right. I mean, sometimes there are judges who will put people on home detention because they want to make sure that they're staying away from other people. Mm-hmm. And if we're making people actually pay for that, and then the services aren't, if you can't find out whether or not that's actually being the case, I think it's doubly bad. It's bad for it's also bad for the defendant having to pay in the first place. But let me again go back to the practical question. Who will determine it? Will it just be because they have the services of the Office of the Public Defender? Is that it? Or is it possible for somebody who is pro se or a private counsel who may just be picking up the case? How will that be determined? How will it be determined that they qualify for this?
Right. So again, don't want to speak on behalf of the bill sponsor, but the intention of the advocates, the intention of the legislation, which, you know, was a recommendation of JOTF's criminalization of poverty report in 2018. You know, the idea is, how do we ensure that that we are facilitating or supporting a process that would allow individuals to still adhere to certain conditions, but it's not anything that would, you know, jeopardize their future success or be able to jeopardize their freedom. And so, you know, again, I don't want to be the only one speaking on behalf of the larger group, and want to make sure that others jump in. But you know, the idea is that if you are, and I'm sure, Mr. Chairman, you know this, when you are seeking public defender representation, right, there are a number of questions that are asked to determine whether or not, and I hate saying this, but to determine whether or not you're poor enough to secure supports and services, right? That's what we do in this country.
Yeah, we check, we
that you're too poor,
we
right?
verify.
And so that same process, I'm sorry, and I'll let you go, Todd, but that same process is, you know, what we thought was just an early first step. If there was any, if there was going to be any determination to prove that someone is poor, why not use something that's already in existence? And right now, indigency determinations are in place for public defender representation. And so the idea is, if you are so poor that you can't afford a private attorney, then you probably are too poor to be able to afford $240 or more a week. Yesterday, I was just at ASAP Home Detention paying $715 in past owed detention fees for an individual who has been under ASAP Home Detention since November 24th, 2020. And so, you know, we're seeing this more and more and more, where these are individuals who are clients of the Office of the Public Defender. These are individuals where Trayvon spoke to JOTF needing to go into court to advocate on behalf of him. I mean, this is someone who is not just looking for employment services and supports and help with home detention, but also is looking for supports and just getting basic things like food stamps, right? And so these are folks who, they ain't got it. And so again, just going back to the initial idea or to the common theme of, if you cannot afford a private attorney, if you qualify for public defender representation, then that same process, that same criteria should be applied to anything that would limit or hinder, jeopardize your freedom. That's
you've repeated it several times, and I got it. I understand that 100%. My question isn't necessarily that. It's when the Office of the Public Defender and when they take on a client, there is a process that happens, and they go through the process and they come out the other side, and they're able to receive the Office of the Public Defender services. And that's fine, and that's great. And I don't question that these are the people who need the help. My question is, how do we go from point A to point B, where they've qualified for the public defender? Who knows? Is this going to be something that the private company has to submit? Is this something that some other agency has to submit? Does the court have to submit it? Does the court say it's not a critical flaw in the bill, and I don't mean to overblow this more than anything. I just, the
process
side of this is what is I think what's missing. And so there's a point A to point B question there. That's why I'm off on the pretrial thing and started talking about Deborah Davis and stuff like that. But Mr. Oppenheim, and then I am going to ask Nicole, because I cut her off twice now.
Why not? You want to go, Nicole?
Let Nicole go.
I mean, I'm not the expert of figuring that out. I would assume that it would mean that we just upgrade the state's process. So if we know that the state does it for folks who have specific sentencing and are coming home, and they're able to identify if these individuals are indigent and that they cannot afford it, you know, my suggestion would be to tap into that system and help to upgrade that system that will then be able to accommodate our pretrial folks because even that system needs some upgrading for individuals who are supposed to be eligible to come out. Folks are waiting months, 2 months, 3 months, 4 months, 5 months to even be released through the state's program. And even people pre-trial I have had cases where people were approved through the state's program. So I would just argue that may be where we begin to dive a little deeper into and helping to upgrade that system right there. But that's just mine.
I fear that I am going to need to admonish myself for taking too much time. So I'm Mr. Oppenheim, if you'd like to respond briefly, that's fine. Otherwise, we think we have Mr. Kearney available and we can give him the opportunity to speak. But Mr. Oppenheim, do you have anything more you wanted to say there?
Everyone that qualified for our office is qualifying under federal poverty guidelines, which isn't necessarily up to date. And there's even a middle ground. Like if you don't qualify for us, that doesn't mean that you're making it in the world. And also, you know, with the indefinite postponements that are going on in court now, these fees are, we can't even quantify them. You heard that from Ball, and I attest to everything that they're saying. We had to use them. And I think it's kind of the way it is now. Remember, they're being released on their own recognizance. Mm-hmm. There's this loose order, you know, that comes in from the home detention companies. And this is a situation where we're working with the devil here. They support this bill as well because they're making a killing here, but they're assisting people in getting out of jail. And that's the system we have. So they're going to do everything they can to keep this up and running. They send their stuff to the judges. The judges can verify that our clients are in fact represented by us. And it doesn't seem like any more of a problem than the issue now of what the order actually gets to them.
Okay. All right. Okay, let's see if one last person then. Kearney, are you there? Oh, Mr. Kearney. There he is. Mr. Kearney, you need to take yourself off mute.
Unmute. Can you hear me now?
Right, good. Let's hear from you for 2 minutes.
Yes, sir. I'm gonna do it quickly. I'm representing my grandson. He's 21. When he started on ASAP, the initial start was $282. 14 days later, I had to pay $214. Then I've been paying $184 every 2 weeks or $364 a month. You know, that's hard at any time. And during COVID, it's the worst thing I could think of. But I'm trying to do everything I can to keep my grandson from being incarcerated in that place during COVID, because that would be the worst thing I could think of right now. So I've been fighting it, but it's going to come to an end because I've been postponed. My court has been postponed and I have to go back. I can't go back again. He can't go back again until April. So I'll be paying that until that happens.
Okay.
Yes, sir.
Questions? Thank you so much for being patient with us. Are there questions for Mr. Kearney? We do thank you very much for taking the time to be with us, Mr. Kearney, and all the rest of you, and all that you had to go through, Mr. Kearney in particular, though. Thank you very much for putting up with that.
No problem. Thanks for hearing me, sir.
No, thank you. All right.
Thank you, Mr. Chairman, for allowing the time for us.
No problem. I think that that finishes up the testimony on House Bill 316. We all thank you very, very much. And we're now going to go to House Bill 102. 102 is 3 minutes for the sponsor, Delegate Hill, who is with us. And then there are 1, 2, 3, 4. All right, 4 more with Delegate Hill and 2 in opposition. So what it'll be is we'll do Delegate Hill and Julian Holman, Kim Haven, Joan Shreve, and Zahra Siddiq. Those 4 will testify after Delegate Hill, and then we'll take questions. And then after that will be Stephen Sanders and Mark Rowley. All right, Delegate Hill for 3 minutes, please.
3 minutes, Mr. Chairman. Thank you very much, Mr. Chairman, Madam Vice Chair and Committee. Today to present House Bill 102, Correction Services, Inmates, Labor, Job Training, and Educational Courses. Essentially, this bill attempts to allow Maryland to leave the vestiges of slavery and peonage behind by requiring that inmates who are employed through the department as well as through the offspring of Maryland Correctional Services or Institute, MCE, be paid a minimum wage. It's pretty straightforward. It requires that they be paid the minimum wage, the state prevailing minimum wage. It removes provisions that from that money, deductions be made for room and board. And that's simply because I'm trying to approach this as a justice issue. And I think that if it's the state's responsibility to do the rehabilitation, it's the state's responsibility. It does ensure that inmates' wages can be deducted for child support, victim restitution, victim compensation, and other court-ordered financial obligations, which of course would help to build accountability, expand job training opportunities with focus on marketable skills and partnerships with the trade and labor unions. Much of that work has been outlined with Dollar, but there seems to be a disconnect between what Dollar recommends and what the department's been able to actually implement. And then to increase inmate offerings for education across the board. I'm going to take, I think, the last minute and a half just to sort of address some of the issues that were raised in the department's letter in opposition to the bill. And this is based on conversations that I have had earlier with Jennifer Beskin on behalf of the department, and there were no commitments made, but I do think that we can work through this bill to come up with a system that's better than what we have today. Essentially, they have issues with the numbers. And if we go through their points, they point out that this would have a significant fiscal impact, and in fact would make MCE much less able to be self-sustaining. They don't say that it couldn't be self-sustaining, but less self-sustaining. And I think that MCE was not created for the prime objective of being a self-sustaining agency. And if that objective is getting in the way of its performing its prime objective, which has to do with rehabilitation and allowing the inmates to have the skills they need to re-enter society successfully, then we indeed do need to take a harder look at what their priorities are. They then talk about some concerns about the education piece and how the bill is written to say that any inmate who wishes to participate in education programs should do so or be allowed to do so. And I absolutely respect their concerns about safety and security and would be happy to modify language and have come up with some language that we tentatively can agree to that would make it clear that inmates who wish to participate have to qualify, and that includes meeting criteria for safety and security. They then go on to talk about how the cost of housing is really only taken from the few inmates who through the program are hired outside, and that they're actually required to receive the prevailing minimum wage.
Delegate, got to wrap up.
That's about the end of it. I'm done then. Thank you.
All right. Thank you very much. Now we're going to go for 2 minutes each. We'll start with Julian Holman, please.
Hi. Thank you to the chair, the vice chair, and the honorable committee. My name is Julian Holman. I'm a citizen of Prince George's County. I'm also a University of Maryland, Baltimore County graduate student, and University System of Maryland Anti-Prison Labor Coalition member. I wish to express my support for HB 102 before you today. Prison laborers make as little as 17 cents an hour, which can be reduced further by room and other deductions. And additionally, spending time in prison halves annual earning potential, which results in massive career losses and hurts the families of incarcerated people. This harm is disproportionately visited upon Black people, considering that 70% of incarcerated Marylanders are Black, despite Black people comprising 30% of Maryland's population. So ultimately, for pennies a day, an overwhelmingly Black prison population produces items such as the state license plates on the car you ride in, the chairs and desks we sit in at a Maryland school or state house, and the masks and sanitizer used by state employees to combat COVID-19, which often these prison populations don't have access to themselves. And as a product of the Maryland educational system, learning this made me feel incredibly ashamed and embarrassed, because this is slavery, and unfortunately it's entirely legal under the 13th Amendment, where it states, quote, "Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States," end quote. The true solution to the problem is to remove any incentive to imprison our most vulnerable. And until the passage of a divestment bill, partnering with unions and trade groups to develop more relevant training and education, providing fair pay, and holding the Department of Public Safety and Correctional Services accountable to reporting to the legislature, will orient Maryland correctional enterprises away from profiteering and towards rehabilitation, empowering incarcerated Marylanders. Thank you for the opportunity to present testimony, and I urge all delegates to return a favorable report on HB 102.
Kim Haven for 2 minutes, please.
Thank you, Mr. Chairman, members of the committee. I'm back. I'm here today in support of House Bill 102. I understand the concerns that have probably come up with the fiscal note, but I want to point out that MCE makes products, provides products and sells them at market rate. And I know this because I was employed by MCE during my incarceration. And while I was a clerk, I made the high end of the pay. There were people that you only have to work 1 day a month. And so 1 day a month at 90 cents a day is not going to allow you to buy your personals, send money home, buy Christmas gifts for your kids, pay court-ordered pay court-ordered payments. This is something that should happen. The Department of Public Safety and Correctional Services and MCE is just a giant black hole of money. And so there is no reporting out on inmate wages. There is no reporting out on how that money with MCE is used and expended. And there is no concerns about safety and security for programming, because they already do that. There are programs behind the fence that you cannot take if you have certain offenses. So for them to put that up as an objection is just a red herring. So I urge support of HB 102. I do realize the fiscal note is going to be high, but if MCE is making market rate for the desks that you are sitting at, the desks that our colleges and universities have to buy, I think we can afford a prevailing wage. Thank you so much.
Joan Shreve for 2 minutes, please.
Good afternoon. Thank you again for the opportunity, Chairman, Vice Chair, and members of the committee. I'm a social worker at the Public Defender's Office, and we support House Bill 102. Working alongside attorneys, social workers throughout our agency may be tasked with conducting biopsychosocial evaluations for mitigation purposes, assessing and linking clients to evidence-based services, and when needed, integrating those services into pretrial sentencing or alternative sentencing plans. Social workers in our agency are concerned with the conditions in prison and support that bills that offer opportunities for our clients to succeed in the future. Many clients I have worked with have held high-ranking, skilled positions through Maryland Correctional Enterprises. Those who have been in MCE shops were ultimately released were far more likely to find employment in skilled jobs. However, despite decades of employment through MCE, my clients also had no savings upon release and have had to rely on elderly family members, many who are on fixed incomes and have limited financial resources. Many of my clients have been extremely hesitant to rely on family members for financial support upon release, knowing the burden they will place on them. They are eager and motivated to become self-sufficient as quickly as possible, but reentry is a process and can often take 12 to 18 months to establish stability and independence. Providing fair compensation, no less than the minimum wage for the skilled labor they provide the state, will help them create a safety net for themselves and their families, and will help them stabilize quickly upon release. This bill helps reduce barriers to financial stability and independence. OPD supports this bill to fully compensate MCE employees for their skilled labor and the expansion of training and educational opportunities. For these reasons, we ask for a favorable report on HB 102.
Am I right in that Mr. Rubin is not here?
Correct, yes.
Okay, that's fine. All right, Zara Siddiq. And if I mispronounced your name, I apologize to everyone all the time anyway. Siddiq.
Thank you. Good afternoon.
My name is Zara Sadiq, and I'm president of NAACP at the University of Maryland, where we work to inform youth of the problems affecting minorities and to advance the economic, education, social, and political status of minorities and their harmonious cooperation with other peoples. I'd like to start by thanking Chair Clippinger and all the other members of the Judiciary Committee for the opportunity to share our thoughts on this important bill, as well as Delegates Hill and Feldmark for introducing the legislation, which is vital to improving the livelihoods of incarcerated people. I'm speaking to you today to express our support for HB 0102. It is time that we shine light on prison labor and treat these people as equals rather than exploiting their labor for capital gain. According to the Maryland Correctional Enterprises Annual Report in 2019, incarcerated people's pay ranges from 17 to 36 cents an hour for a 4 to 5 day work week. This minuscule amount of pay cannot compete with the inflated rates of items that are sold to those who are incarcerated in said prisons. While incarcerated peoples make cents a day, the minimum wage in the state of Maryland is $11. This inequality is astounding and needs to be addressed. Prisons rely on incarcerated people's labor in order to function. This mistreatment and inequity amongst those who are incarcerated resembles illegal and modern-day slavery that has been alive and well for decades. This bill is our chance to take a step in the right direction. Prisons should not have the right to deduct any earnings from incarcerated people under any circumstance. The inappropriate deduction of incarcerated people's wages is a unique and unfair practice that allows prisons to further strip away the freedoms that these people deserve. Jobs in prisons are said to be more than just a paycheck, but rather to prepare inmates for the outside world when they are released. But how can these jobs prepare them for the outside world when they are treated unfairly, do not make nearly enough pay, and are faced with the threat of losing what little they have earned for the prison's convenience? This treatment is inhumane and intolerable in this day and age. In a state where we have the highest rate of Black people incarcerated, systemic inequality needs to be addressed. This bill takes a step towards remedying this issue, which is why I'm asking you to vote yes on the HBO 102 bill. Thank you.
Right. Okay, those are the people who are here to testify in favor. Before we go to the opponents, let's take questions for those in favor. There are two so far, Delegates Arikan and Watson. So we'll start with Arikan.
Thank you, Mr. Chair. Thank you, delegate and panelists. I'm not sure if the advocates were aware, but that program, when they were comparing it to slavery, is voluntary. It is not indentured servitude. It's not enforced labor. It's a voluntary program to join. You don't have to work if you don't want to. I actually spoke to those people when we went there. Did you know that when you compared it to slavery, or?
Is that the question, Delegate?
Yeah. Does everybody know that it's voluntary?
Yeah. It's also like, as I said, peonage. It's also like sharecrop labor. That's voluntary too. But when you pay people dirt poor and then you subtract the cost of living out of their wages, and as was pointed out by one of the other panelists, Ms. Siddiqui, and then you charge them exorbitant amounts for everything from a telephone call to sanitary products, yeah, that's a form of slavery.
Yeah, I think the overcharging is disgusting. So we have to work on that
And
for sure.
Delegate Arikan, you're right, it is voluntary, but when you're inside, you have to do one of something. There is no just pressing your bunk and doing your time. You're either in school, you're working on the grounds, like in the kitchen or, the grounds or whatever, or MCE. MCE is where everybody wants to go. And that wait list is extraordinary. There is no just hanging out. So while it is voluntary, the institutions make you do one of those three things. There's not the opportunity to do anything else.
Yeah, and so are we anticipating that if we raise them up to the minimum wage, that then we're going to continue to sort of garnish the costs of care? Is that what the idea is?
I think the idea is to focus more on our rehabilitative function, to allow people to be accountable for what they've done before they entered the system, to allow them to begin to earn some money and make some savings so that when they leave, they're not just given a bus token and a wave goodbye and best of luck and a Medicare card, that they actually have some savings and they can have the opportunity to take the training that they should be given that should be consistent with what the needs are. And that's another issue we can talk about if that question comes, and that they can be successful so that we can lower the recidivism rate.
Okay, and so that
Some
would
say that they should
they
then
would
be
pay all that
deducted. The ones that are deducted now are only the people who, through the department, are working outside for other entities who are paying. They are being paid a prevailing wage. And if you look at the testimony in their report, they say in their annual report, they talk about 8 people getting about $11 an hour, who are actually being paid a prevailing wage.
So just to clarify, you are anticipating that the cost of things and any sort of restitution they owe would be subtracted before they could build savings?
Yes.
Okay, thanks.
But not room and board.
Okay. Before I go to Delegate Watson, it's been said a couple times, and I'm just going to make sure, you would ask for them to receive the minimum wage or the prevailing wage?
I would ask for the minimum wage, but I am comfortable with, and when I discussed it with the department earlier, I said there's a big gap between 70 cents an hour and the minimum wage. So there are all kinds of numbers. We can talk about a training wage. We can talk about all kinds of numbers that is more than what the vast majority of them are making now. So to me, if we say that, you and I and our family members deserve a minimum wage when they're working hard, and we know the quality of the products that these folks produce, particularly through MCE, I would like to see that. But I mean, I'm open to it, and it's your committee's bill. So,
I guess where I wanted, and Ms. Haven mentioned this too, is she specifically, you also just said prevailing wage, which is distinct and different from a minimum.
Right. The current federal law by which, through the grant process or through granting process, the department allows for prisoners to be hired out. That law requires prevailing wage.
Okay, got it. Okay, I understand now. I understand the context. Delegates Watson, then Conaway and Malone. Delegate Watson.
Thank you, Chair Clippinger. Thank you, Delegate Hill. Quick question for you, Delegate Hill. So I had the opportunity with Secretary Green to go and visit some inmates who were working with MCE. And in effect, they were working, in my opinion, as subcontractors for some state agencies. Specifically, I'm referring to the Department of Motor Vehicles. Someone just testified and said they prepare you for the outside world. And my question is, while I agree with giving them more funding, when they get out, are they able to go to the Department of Motor Vehicles and get hired?
That's an excellent question. And I know that we've worked a lot in the past 4 years on trying to make sure that certifications for certain kinds of trained labor do not ban people with prison records from getting that job. When I speak to the people in the industry, for instance, we just had a conversation with people in the printing industry, and their problem is that they want to work with the inmates and they're allowed to. They're limited by some of the department restrictions, but they need to give them software training, and software is not allowed in. And so what they would like to see is that the department actually works with technology to identify software that they would allow them to have access to, so that their training can be current with the kinds of jobs they would get when they go out. And that's why the bill also asks, and perhaps it was mislabeled as saying for the department, it should say dollar. The department makes a point that it's not their job to define what jobs are out there and what programs they should participate in. But you're correct. There's a lot of work that would need to be done to make sure they're being trained appropriately so they can get that job.
Right. And I understand being trained and go out and getting a like job. And we as legislators, the only thing we really have control over are state agencies.
Correct.
And in going to the prison where I went to, I saw inmates doing the exact same function that folks currently working in the Department of Motor Vehicles do. And I would think, something very, very tangible would be to guarantee them even if it's a probationary period, to be immediately employed and be able to fill a vacancy so they can use that exact same skill set that the state has been taking advantage of for so long.
I would love that amendment, Delegate. I would love that amendment.
I would also like MCE to hire the very people that work for them, and they don't. MCE only hires a very few formerly incarcerated people, and people that have applied for the job, it's taken 7 to 9 months, and by that time, they've already accepted other positions.
Thank you very much.
Delegate Conaway, then Malone.
Thank you, Mr. Chairman. Thank you, Delegate Hill, for this bill. I was wondering, was MCE, was it functioning in 2020 before the COVID epidemic came along?
Yes, they make a point that the COVID has impacted, and so some of the numbers that they're using are based on their 2019 data, but the report that I think we put in your bill file, the MCE annual report, is a 2020 report.
Was this an agency that was refurbishing the furniture also? Did they have the furniture shop?
The furniture that we in the State House?
Well, yes.
MCE, yes.
Thank you so very much.
Thank you.
Delegate Malone.
Delegate Hill, thank you for your presentation. You mentioned that these earned funds could be used to pay child support. However, under current law, if you're sentenced to 180 days, the child support payment is abated. Would you be open to an amendment that would remove the abatement of child support for incarceration?
Provided that people are earning a living, right? So we wouldn't want someone who's not earning or who's earning 30 cents a day to be then held liable for that child support. So we can't have it both ways. So yes, Delegate,
could you provide a provision that if they start earning money, there's some type of requirement to notify the Office of Child Support Enforcement that they're now earning money?
Sure.
I think that would improve the bill.
Thank you.
Are there further questions for the panel? Delegate Bartlett.
Thank you, Mr. Chair. Thank you, Delegate Hill, for bringing the bill. With the premise that cigarettes or other things are used as currency in the prison system, if that is true, do you believe that the increase in pay could decrease the amount of crime in jail or the need for this type of exchange that goes on in the prison system?
I think that's an excellent point, Delegate Bartlett, and I would indeed, I think we would see improvement in a whole lot of things, and that is one I had not thought of, but I think you're spot on.
If I can offer some insight based on being inside, it would help. People would be able to buy the very personals and things that they need, stamps to write letters to their kids, phone calls, shampoo. You have to buy your own shampoo. You have to buy your own soap, your own toothbrush, toothpaste, laundry detergent. All of that you have to pay for. And so when you can't pay for it, you barter. And inside we call them side hustles. And that's how people survive, because they don't have the economic means by which to survive. And so if people were working and were being paid a wage that actually allowed them to do that, then we would see a decrease, I believe, in that barter system and also in the crime that it inevitably draws.
And if I may add, it would also decrease the burden on their families, who have to often look to find additional money to send them so that the inmates aren't dealing with these side trades, so that the, being incarcerated has, ripple effects on the family and adding to the systemic and generational poverty that we see over and over again, which again adds to recidivism and other issues.
All right, I believe that was the last question for the proponents. We want to thank you all very much for being with us this afternoon, and now we'll go to the opponents. All right, and that will be Stephen Sanders and Mark Rowley. Mr. Sanders? Uh-oh. May not have been added as, oh, well, I see Mr. Rowley. Mark Rowley.
Yes, yes. Can you hear me?
Yes, would you like to go ahead, please?
Good afternoon, Madam Chairperson and members of the committee. I'm Mark Rowley. I'm the Chief Administrative Officer here at Maryland Correctional Enterprises. I stand in opposition of this bill, though I do understand and appreciate what you're trying to accomplish. Maryland Correctional Enterprises is not just a work program, it's a training program. We have people who are learning an AutoCAD program, which is part of an interior design program. That cost would be $33,000 a year if you were on the outside. There's a meat cutting apprenticeship program here. That would be $3,000 per semester. We have inmates that are learning Microsoft Office, Excel, Microsoft Word, PowerPoint, Access, and a variety of tools and equipment. The current expense to keep a person incarcerated is approximately $49,200 per year. We're already consuming $49,200 per individual each year, and we're training them. In addition to the compensation that they get, each person is entitled to 10 additional days of diminution credits. So they reduce the sentence of each person by 4 months per year. And again, not only do we pay the inmates, but we also have to pay for the raw materials that they're working on. We also have to bring people in, civilians in, and we have to pay them as well as the various manufacturing costs that go along with this program. So it would be tremendously challenging to pay $15 per hour or whatever the minimum wage would be. It would bankrupt us. And I do believe the Correctional Services article says that we, Maryland Correctional Enterprises, should be a self-supporting agency. And we have been so, I believe, since its inception. We also have a program that, and I'm almost finished, we have a program that when they're about to leave, we actually have classes for job readiness, thinking for a change. We're trying to prepare them. We also have a person who's working full-time, trying to find employment for these highly motivated people. We've hired probably more than 20 people who were previously incarcerated here at Maryland Correctional Enterprises. And we also bring in, I don't know if you're familiar with Michelle Singletary. Michelle Singletary is a columnist for the Washington Post. She comes in and she teaches our financial literacy piece. So we are doing a lot of things. And as a former member of the National Correctional Industries Association board member, I can tell you, Maryland is standing out far above a lot of other states and what we're doing for our inmates. Thank you.
Thank you very much. The chat's going to be disabled. We don't allow people to testify even in writing while other people are testifying. Thank you very much. Going to go now to Mr. Sanders. Stephen Sanders?
Yes, sir. Can you hear me?
Yes.
Thank you, sir. I'm going to limit my testimony to the impact of increasing inmate wages to the state minimum wage on MCE. Good afternoon, Chairman Clippinger, Madam Vice Chair, members of the committee. My name is Stephen Sanders and I'm the CEO of MCE, Maryland Correctional Enterprises. As you're aware, MCE is a self-supporting prison industry arm of the Division of Correction. Our primary mission is to provide inmates with work skills and work ethics to enhance their employability upon release while maintaining our self-sustaining status. You have our department's position paper, which opposes the paying of minimum wages to MCE inmates, as it will diminish our ability to fulfill our mission. The passage of HB 102, as currently written, will increase our special fund expenditures by approximately $26 million, far exceeding the funds available as our business plan goal is to maintain a minimum 3% profit margin. That 26 million, by the way, is not based on $15 an hour. That would increase the number to $30 million a year. These increased expenditures associated with paying minimum wage would result in the bankruptcy of MCE. MCE's ability to maximize offender employment and training opportunities would greatly decrease, diminishing our ability to touch thousands of lives and provide millions of training hours to incarcerated individuals throughout Maryland's prison system. Our program is 100% voluntary. We often have a waiting list of inmates seeking employment and training opportunities with MCE. Studies of correctional industries across the nation continue to show that correctional industry programs have a positive effect on reducing recidivism rates and therefore making our communities safe places for all of us. A reduction in our programming also creates a further strain on correctional facilities, as additional correctional custody staff would need to be hired for institutional supervision previously provided by MCE. However, we believe the current rates of pay are appropriate and allow MCE to remain effective and efficient by maximizing inmate employment opportunities. The current rates of pay also allow us to remain self-supporting and therefore not having to depend on general fund appropriation. We believe it is—
Sanders, if you would please wrap up. Thank you.
Yes, sir. We believe it is in the best interest of the state to have a strong and vibrant MCE. We therefore respectfully request that any reference to MCE being required to pay minimum wage be removed or amended out of this bill.
Thank you very much. Are there questions for this panel? I don't see anyone as of yet. All right, I don't see questions for this panel. We thank you all both very much for your testimony. And that's going to conclude the testimony on House Bill 102 and the testimony on all bills for today here in the House Judiciary Committee. Committee, tomorrow at 1:30, we will have a fiscal briefing from the Department of Legislative Services. Then we will have bill hearings starting at 2:30 tomorrow.